Good morning, everybody. It is Thursday, August 13th, and it is day 13 of the Lindsay Clancy trial. I'm not even sure what to expect today, but let's get to it. For day 13, as most of you who have been with us know, Bob is in Massachusetts. He is in Plymouth, and he is probably in the courthouse by now, I'm sure. I guess I should get the stream up and going. So here's what's going on at my house. Doing all the things by myself. And, I'm like not the best with my time management. So this morning, whoops, wait a minute. Hold up, wait a minute. All right, let me share. So this morning, I get up and I have, sleep lines all over my face. And I don't know, when Bob and I went away, I must have left my foundation there. So I go into Scout's room and I'm like, all right, what's she got? What's she got? And all she has is what is it, face sculpting or framing, whatever the kids do these days that I do not know how to do. So it's like this really weird dark makeup, right? So I'm like, all right. I mean, I've been wearing makeup since I was a little kid. I'll figure this out. Yeah, no, it doesn't figure out easily. I know I saw one of my friends, well, I've seen many people now, but the first time I saw one of my friends do it, who's similarly complected as me, she put on the darkest, brown, foundation or whatever you want to call it on her face. Yeah, so it looks like I've got oh Lord. And I was like, what? I was like, how oh, contouring. Thank you. That's just a matter of my brain fog, not my lack of I did know that word. Contouring. So and I was like, no, 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 no. There's no way this is going to end up looking normal. I mean, look like Jersey girl, look like this my friend was putting on contouring coloring that is like your complexion. And then I watched her do it, and all of a sudden, somehow she looked normal, but I, you know, I couldn't do it. So, maybe it's whatever. It's like a thing having to look at yourself on the screen every day. It's annoying. It's annoying. But let's see. So there is a wonderful, amazing human being who slept in my house last night. So I thought was going to come on with me this morning. Who was not here. That would be Cameron. So I was tempted to go wake her up, but I figured if she planned to come, she'd be here. She would have set an alarm, but I'm sure she's definitely going to join us at some point. Yeah. All right, so I guess we should talk about where we left off yesterday and where we're headed. But let me first say hi to Courtney Hoster and Winnie's mom. Welcome. Family hugs. Glad you guys are having fun with the jewels. We appreciate that. So, I don't know what's going on over there because I thought they were wrapping up maybe it was because that's the idea that my husband got, was that the prosecution was, like, about to end, but I see no end in sight. They just keep going. They just keep going, and yesterday, it's, like, hard to think about to go back now and be like, "Okay, what happened yesterday?" And then I'm like, "Oh, oh, yeah, that horrible thing happened yesterday." I really, really think that the prosecutors got, like, calls from their friends, neighbors, loved ones, the attorney next door, and their you know, senior attorneys, if not the DA himself. This is just all obviously presumption and make believe at this point, but I'm going with it, okay? So just remember, make believe story that y'all are fucking up. Y'all are fucking up. I have never seen a more sympathetic defendant. What are you doing and why? There has got to be people saying, dude, you're losing this. The whole world is now, heart is breaking for not only the 3 little kids, but also, if it wasn't before, also now for Lindsay Clancy. And the way they went so hard, and I'm sorry, whether you think Lindsay Clancy is criminally responsible, is a cold-blooded killer, is the worst person in the world, or you think, as I think many of us do, that this is a lack of criminal responsibility case at this point. It's still going, I know. There is a level of respect that needs to be had for the jury. You take these people, and I know I went on a mini rant about this yesterday, but I just have to say it again. You know, you take these people, you ask them to do their civic duty, and then you shit all over them. You have no regard for the fact that this is not a drug case. This is not, somebody robbed the local store, even a home invasion, any of the horrible cases that exist in the world. This is a traumatic case for these jurors to sit through, and they need to be respected. And they're not. They just do not care to expose them to more pictures than they have to. And I understand. It's the thing that has to happen at all trials. Are they trying to establish that this was, atrocious? I don't think they needed this to establish any atrocity that they need to establish. But to keep exposing the jury like that and splitting it up like that, and, you know, just giving them way more gruesome details than they need, even if we take it away from, "Look what you're doing to Lindsay Clancy," look what you're doing to the jurors, and it's not necessary. And now you done and fucked it, because I think, yes, I remember from the chat yesterday, there are a lot of people, I guess. I haven't been out on in these streets on social media. I've been doing this, dealing with the house, and then, you know, I like pop it on to check Bob's, posts, but that's about it. But that there's people out here, ay, 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 who think she was faking. I got to hear some of Bob's live yesterday, his Inside the Courtroom live, but, um, other than that, you know, I don't know what people are saying, and I know I talked to my husband, though, beforehand. Oh, he says, um, "A crowd is gathering, awaiting admittance into the courtroom after a brutal day yesterday. I can't imagine what's to come today." Hey, that's what I'm thinking over here. Oh, and legend Rosemary Scapiccio is in the house today. So she must know something about who's being called and why they're being called, or maybe she's just showing up on days that she can find the time. For those of you that don't know, Rosemary Scapiccio is a well-renowned, well-respected, long-time fighter for the rights of the people, criminal defense attorney in the Boston area, who is Lindsay Clancy's civil lawyer. So, also, Bob made some veiled threat while he was still here that when he got to Massachusetts, he's gonna go into Rosemary's office, and he's gonna say, "Lady, I'm taking you to lunch." I don't know, something like that, but when he said it, it was not as ridiculous as what I just did. Um, and so I'm sure he is going to be showing her the love, like, fangirling, but also just very respectfully, honestly, telling her how much he respects her. And for those of you that didn't watch our, um, Sean Ellis coverage, she represented Sean Ellis. He's of Trial 4. He came onto our show. We have an episode with him. So check it out if you didn't. It's like he's an amazing human being who was wrongfully convicted, who Rosemary fought for decades, like to get released and to show the Boston corruption or the Massachusetts corruption. It's like all these same areas, got these little towns. That might have been Boston proper. I don't know. Don't hold it to me because of my memory. Uh L'Oreal, no, Lorelei, sorry. Annie says, "Shame on this judge. He could have stopped this." You know, I don't know under the present law whether he could have or not. I think he could have. I think he could have. You can always use 403 to say something's more prejudicial than probative. And maybe this ends up, well, hopefully it doesn't end up being a case that changes the law in any way because hopefully there doesn't need no need for an appeal, you know. Meaning if she's found not guilty, I mean guilty but not criminally responsible, there's nothing legally to appeal. So, the issues about the prejudice versus the probative value of evidence of the offense in this manner being admissible will never get considered by a court of law, you know? So, thank you, Lorelei. And not that Nikki says, "Is there a GoFundMe?" Hold on a second. Is there a GoFundMe for Lindsay's legal fund? Um, I've heard her parents liquidated their retirement for her defense. I know none of that. I know at this point, um, they as of for this trial, I can't imagine that they're in need of additional funds, but they very well may be. I don't know. Maybe the family, I don't know. So I don't know. Sorry. Cherie says, "I do not get the eye for an eye." Let me make sure this shit is playing. Yes, yes. Hold on. Make sure our subtitles are still big. Yes. I also increased um, the background, the blackness of it. So it was at 75. I put it at 100, which I thought made it a little more um, visible. But I guess we shall see. All right. All things are a go. So I do not get the eye for an eye mentality. Would anyone expect a paraplegic to jump out of their wheelchair and do a marathon? Lack of empathy and understanding. She has the worst punishment already. Yeah, the eye for an eye mentality is not supposed to be, you know, what the law is really about, but clearly it's what so many people, you know, in the public want to apply. But, it's not really an eye for an eye when there's these mitigating underlying circumstances in any situation. Obviously, here, the mental health, you know. Um, but I do think, there needs to be changes to the law on mental health and insanity. I mean, look, you guys, this state, Massachusetts law on not criminally responsible is way better than, like, I don't know, every other state's law that I've had to look into, be aware of, that I can think of to date, because it has both sides of it, that it's, either, you know, you couldn't tell the difference between right or wrong, or you couldn't conform your conduct to the law, and it puts the entire burden on the state to prove, the Commonwealth to prove all of the elements beyond a reasonable doubt, um, on that second prong as well. So, you know, but it's still shit. It's still shit because I don't know how hard it is to, I guess, demonstrate or disprove that you were compelled to act, you know? But I also think if you followed the law, it's almost impossible to prove beyond a reasonable doubt. Once the defense puts on the evidence that she had command hallucinations, she didn't feel like she was in control of her own body, she couldn't stop what was going on, you know, is it how is the defense, how's the prosecution proving beyond a reasonable doubt that she could? Well, their answer to that is this phone call and the search for the distance and the sending Patrick out for to go get the food and to stop at the store. Like, I don't even remember if they put on this evidence already about the searching and the timing. I know they put on Patrick to say answer the phone call, but I just don't know that the timing piece has been put together. I know this Commonwealth is trying to say she answered that phone in the middle. I don't know if she did or not. Like, that timing would have to be so set out for me that they could actually piece it together and prove to me that was in the middle. Like, what, there was only 1 minute left, there was only 2 minutes left, that's impossible. He was at the CVS, so he hadn't gotten the food yet. And, the question with the search, I have to say that the again, uh, well, I need to pull up the amended. Hold on a sec. I got it up here just in case. And I say amended, I mean Lindsay's complaint, because you guys know that I was looking at a first amended complaint and not the second amended complaint. So I was given bad intel on who the parties were. But so I'm just going to read from this. Um, I'll just, yeah, I'll just read from it. On January 24th, 2023, you know what? I'll put it up. I'll put it up. Just going to make me, I'll have I don't hear any movement anyway, so, but I'll have it in my ear. So if it starts to move. Okay. This is what the complaint that Rosemary Scapicchio filed, that's coming from Lindsay's version of events or the medical records. I mean, I won't know for sure until we get the defense's side, the defense's experts, to see where these quotes come from. But it's her position. It's the version of events that if Lindsay was up there talking, Lindsay would be saying. On January 24th, 2023, Lindsay woke severely depressed with suicidal thoughts. She gave the children breakfast. She took Cora to the pediatrician because Cora complained of a stomach ache. Later, she went to the backyard with the children, built a snowman, and sent a picture to Patrick and her mother. The suicidal hallucinations continued all day nonstop. Later in the afternoon, the voice began saying, "You should harm the children." Lindsay thought about dinner and realized she had not prepared anything. She asked Patrick about takeout. She looked at a map to see how long it would take, because she did not want to be alone and needed help. Okay? She did not want to be alone and needed help. That is the very same this sentence too, under January 24th, 2023, is the entirety, or the strongest thing that I think the Commonwealth is really leaning into here, okay? That she asked Patrick about takeout. Using these same facts, okay? Using the same facts they're saying, she made a decision to harm the children. She sent Patrick to get takeout. She had looked at a map to make sure he'd be gone long enough so that she could do the deed. Okay? So these are the two stories, essentially. So going back to the body of the complaint, as soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. "This is your last chance. Kill the children so you can kill yourself. This is your last chance. You have to unalive the kids." Going on, going on. Lindsay felt a force come over her. Lindsay experienced command auditory hallucinations. A demanding, powerful male voice explicitly ordered her. She felt an overwhelming, irresistible compulsion to comply, entering a dissociative, dreamlike state where her physical actions felt utterly disconnected from her conscious volition. She perceived her, quote, body was just acting, and she was merely, quote, watching herself do it. She reported she had no choice but to follow these compelling directives. Lindsay described, "I lost control. I lost all control. My body started acting without any control on my part. I was just following commands. All action." The voice demanded action. Lindsay proceeded, as alleged, to strangle each of her children, uttering, "Go to God, baby." Following these actions, she undertook a severe suicide attempt, ingesting a substantial quantity of various medications, self-inflicting lacerations to her wrists and neck, and jumping from a second floor window approximately 20 feet to the ground. So, and then it says that Lindsay consistently maintains her actions were compelled by a hallucinatory voice, not a conscious decision, and expressed profound, enduring love for her children. So that is where basically this case lives and dies. In these, and we've been over this if you've been with our channel several times, 9 paragraphs. For the most part. So it begs a couple of questions, okay? If during that period, since she left the house, she's following auditory commands, hallucinations, she's only doing what the voice told her. What I'm gonna need to hear from experts about is, so the voice told her to answer the phone, or she answered the phone before the voice got really bad? Because you said as soon as, and again, this isn't going to, she's not testifying, but just assume this is her story, and let's, use it as that. As soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice, okay? She had no choice but to follow these compelling directives. So why did she answer the phone? If she lost, as she says, "I lost all control. My body started acting without any control on my part." I'm just going to need, these are things that I'm going to need the defense, and I'm going to expect the defense's experts to touch on and to answer, you know, and, we're going to need an answer, at least in the way I feel. I'm going to be listening for answers about why would, you know, should she have known, if she was so fearful about being left home alone? All right. She says she looked at the map to see how long it would take because she did not want to be alone and needed help. Okay. So could she have known at that point? And could she have stopped it by saying, "Hey, I don't want to be alone"? But she had been dealing with these kind of thoughts for a while, so I can see conceptually how an expert can explain this to me that, you know, she's been dealing with these thoughts. So there's no reason that you can't assume that she knew she was about to do it. She's been probably fearful of being alone for some time and knows she needed help for some time. Um, but you got to look at the evidence objectively. It's bad evidence. It's bad evidence. And I want to know, how do you guys feel about that? And don't attack anyone for saying whatever it is that they're saying, but does that leave you with questions? Does that leave you wanting, to um wanting to hear something or anything specific from the defense's experts when they put them on, you know? So Miss Rattle says, just a thought, Lindsay Clancy could have picked that restaurant because the round trip, when including CVS, may have been shorter. Absolutely. I 100% agree with that. If you're going to send, and I know Cameron made this point, let me just pause it and then I'll because the court's back. All right, let me put this back up. Ah,
All right. Well, good morning, everyone. Good morning, counsel. Good morning, Ronna. Good morning, Ms. Clancy. All right. Before we bring the jury in, could I talk to counsel over here just for a few minutes?
all right, perfect. So I can finish my thought. Cameron said, if you're going to plan to send someone away so that you can do something like this, you're going to send him a little further. You're going to wait until he's out at the slopes. He went out once a week with his friends. If this is a plan, a premeditated plan that she could have carried out whenever she damn well wanted, because it's her plan. Her husband, I think, said he went out like once a week with the guys, like had a boys' night or did something. He often went to the slopes for some kind of skiing um or I don't know what he did. She could have picked any other time. So I agree with Miss Rattle. I think the short distance of the trip does go along with what the complaint says, that she was picking a place that didn't leave her home alone too long because she needed help. It's just obviously knowing what happened in retrospect, you're saying, my God, if you were scared enough to check the map to see, well, how long am I going to be home alone? I'm scared to be home alone. I need help. I'd just say, you know what? Maybe I'll go to get the food, you know? But I understand, like, she had trouble even getting up and doing things, but she had been to the to the doctor, with Cora. So saying after the fact, in retrospect, I wish she would have, when she looked at that map, just said, "Hey, I'm afraid to be alone." And maybe it had voiced it in the same way that she was feeling, you know, something different would have happened. But I say that because we all wish, obviously, and I think, um, um, God, my mind's blanking. I know who made this comment yesterday. Said, like, we wish this story had a different ending. It's like, gosh, if you would have just said that to Patrick, like, hey, I'm sitting here afraid to even be alone, But again, we know from what we've heard so far, she's been having these intrusive thoughts, these horrible thoughts for a while. So I can't imagine, if you're going through that consciously you get to the point where you say, I might actually now do something. I might actually carry this out. I don't think in a million years she really thought she would carry it out. So just kind of might have been like her new normal of being like, all right, How long am I gonna be home alone for when he does this? Because I gotta keep these voices out of my head, or I've gotta, do whatever, you know? And it was, I think, Nexus Lexus who might have no, it wasn't Nexus Lexus, but she is she was lacking insight and is a people pleaser from what she sees. I get all of that. I'm just pointing out, like, we have to be aware of the worst evidence, you know? Um, and yeah, Bobby's saying her suit is written from hindsight. Yes, but she made an act, right, Bobby? She did something. She searched a map. And what they're writing there is why, at that moment, she searched the map, not for what the prosecution's saying, that she wanted to know how much time she had to slaughter her children, but she wanted to know how long she was going to be alone so she could mentally kind of prepare for, all right, this is the bout of time that I'm going to be alone. And it 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 made sense to me. Sarah says she's stopped driving. Come on, people, I just read the complaint, right? So this says on January 24th, Lindsay woke severely depressed with suicidal thoughts. She gave the children breakfast. She took Cora to the pediatrician because Cora complained of a stomach ache. All right. So, you know, uh, sorry, wait. I just think we have to be realistic about the worst evidence, and I have said from the beginning that these are answers that me, as a human being, are going to be looking for. I'm assuming that she used, like, a map app, you know? Any of the things, who knows? I don't know, well, I guess we'll hear. Um, but, like, that's the worst evidence, and I see, um, that that it's a problem, you know? But I also can see, and that's what all I'm saying is that I'm gonna wanna hear from the experts about, all right, you've got this period of time where she's kinda hearing these voices, and she's found whatever she's been doing to kind of block it out, to manage it, to deal with it, you know, up to this point, which might also include, if she's going to be alone, kinda mentally preparing herself, so looking at the distance. Um, and Jadzia says she rang around CVS to find one with Cora's meds in stock. Right. If look, if you're only sending your husband on a bullshit trip, right, so that you can unalive your children, and this is your plan, aren't you gonna send him to the CVS that doesn't have it? All right? You're gonna send him to CVS that doesn't have it. You're gonna send him to a restaurant a little bit further away. Like, I understand that all of the state's eh, theory on that, being a plan, it doesn't make sense. It doesn't work. That doesn't mean that there's not questions that the jury's going to be wanting answered. Hello, hello says, just a thought, but am I the only one that thinks the cops outside her door at the hospital was for Lindsay Clancy's protection also? I mean, that's what the prosecution is trying to say. They tried to say that with the last witness, with how many people that might want to hurt her for what she did to the kids. Oh no. No, I don't think that for a minute. Sorry, I thought you meant to, like, kind of protect her from herself. But um they just wanted to arrest her at the end of the day. But, I mean, the last witness the state put on was talking about it being a protective detail. Um, so sorry, let me see what you guys are saying. Yeah, didn't I just The complaint says, if here, I'm going to tell you this much. If she took her by Uber because she didn't even feel safe driving, I guarantee they would have put that in. You know, I don't know. I don't know. I don't know. Trial addict says, what if Red didn't object to leading to control the narrative? If he leads on purpose and they object repetitively, the imbalance looks horrible. I mean, there's that as well. You know, like, but I think it was more like, I'm going to speak when it's important, you know, but it is going to look horrible. They're definitely not going to be letting him lead just because he let them lead. But who knows? At this point, they may be reconsidering their strategy. Maybe not. Maybe they're just over there. You know, I know I started this by saying, oh, they're getting calls from everybody like, y'all fucking up. You've made this woman the most sympathetic defendant in all of the world, you know, but I feel like people would have had to tell her that, you know. I'm sure that Bob will try to get together with Sean. I'm not sure where Sean is uh locally. I'm assuming he's still out there, but I need to get water, but I'm waiting until something's on screen so as to not leave you guys alone. Welcome, twin squeaks. Loving the emojis, the jewel emojis. Hey, Don Burke. Nice to see you again. To hype these videos, I have found watch after stream and then hype. That is true. So, but what I would hype instead of these is really Bob's. I mean, shit, hype them both, but you get that limited thing. But Bob's inside the courthouse videos, because those will be shorter, you know, for people who don't want to spend the whole day watching the trial. But that is how you hype. You have to wait till the live stream ends, and then you can hype it. You have to. What I do is I unlike it if I've liked it already, and when I choose to like, then it gives me the option to hype. Thank you, Dawn. I love when people donate to us just to say something that helps us. It's like the double thank you. So I appreciate you. Let's see. Kate sends $5. Thank you so much. Maybe Megan, maybe not. My DIL. Daughter-in-law called 2 nights ago having a birthday 4 months postpartum. She's going through that. It's horrible.
Court, all rise. Jurors in.
Hey, 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 all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Well, thank you, Madam Clerk. Well, good morning. So here's what I'm going to do. I'm going to ask you those questions, and then we'll talk about our schedule for today. But first off, good morning. Nice to see everyone. Thank you for your patience with us and all the work that you've done so far. So the first question, has any member of the jury read, seen, or heard or overheard anything from any source that would affect your ability to be a fair and impartial juror in this case? Last question, is there any other serious matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? No. Again, thank you for following those instructions. And in regards to our schedule today, it's going to be, I think it's a little bit different. All right. And a lot of it is because of the progress of the case and kind of where we're going. I anticipate we're going to hear a number of witnesses today, and we may break early. All right. And then because of some of these issues, we're not going to be sitting tomorrow. All right. So you don't have to come in. You can come in if you want, but we're not going to be sitting on this case. So my suggestion would be not to come in and to take that and kind of,
Oh, no.
relax as best
I
you
don't
can.
know if we
And
have
then
time to
come in
get
on
the live
Monday
prepared
at
for
9 o'clock.
tomorrow.
And then
Mental Health
expect
Awareness
kind
Day.
of most of those days then going forward will be mostly kind of the schedule we had the last maybe 3 or 4 days. All right. So I just kind of wanted to give you that as information as early as I can so that we confirm that today. So probably an earlier date today, and we're not sitting tomorrow. Okay. And so with that, we're going to return to the Commonwealth's presentation of evidence. And Commonwealth, will you call your next witness, please?
Thank you. Commonwealth calls Kyle Pavao.
Your Honor, while we're waiting, I apologize. Can we just?
Sure,
real
yeah.
quick?
Oh my gosh, I wasn't even talking to you guys. Somebody's lawyer just walked in. That's what I saw. So maybe we're getting a medical professional. This guy right here. Look, check him out. That guy. There he is, walking in. He's sitting down, and he gets his pen out. But, I mean, I can't say for sure. We'll have to see who comes in next, obviously. Oh, no, that looks like a cop. Okay. Oh, maybe that's Reddington's son.
Good morning, sir. Good morning, sir. Can you start right here? Raise your right hand for the clerk, please.
Good morning. Do you solemnly swear that the testimony in the evidence you shall give
Maybe that's Reddington's
the
son.
Commonwealth and the nothing but the truth. Go ahead. Thank you, sir. You may have a seat.
Just step, please.
All right, good morning, sir.
Good morning, Your Honor.
All right. Sprague, please.
Thank you. Good morning. Can you please state and spell your name for the record?
Kyle Pavao, Kyle, last name Pavao,
And where do you work?
Massachusetts State Police.
How long have you worked there?
8 years with 18 total law enforcement experience.
So you worked in law enforcement prior to the state police?
Correct.
In what department?
Town of Mattapoisett.
Okay, that was not Pat.
And are you
Thanks, Jim.
in a specific role or unit at this time?
I was.
What do you do now?
Now I'm a sergeant in field, assigned to the Bourne Barracks.
And previously, where were you assigned?
I was a trooper in the Cybercrime unit.
How long were you in the cybercrime unit?
Roughly
Here, we've got plenty of
3.5
time, so I'll
years or
go
so.
back.
How long
I was
since-
so focused on the lawyer, I didn't see Rosemary. Wait. I didn't see her again. Oh, there she is. Right here at the end with the glasses, the blonde hair, and the blue. As Reddington's approaching whoever that lawyer is. Maybe that's one of his experts. I don't know. They wouldn't be in for a cop. I don't know. No more guessing on my part. I'm going to go live because all we got so far is like he's in phones.
So I am a certified forensic computer examiner.
There you go.
I'm a certified forensic Mac examiner. I'm a Celebrate certified mobile examiner.
See, this is what I've been saying since day one. This Commonwealth will end with what they believe is their strongest evidence, the search for the distance to the restaurant and whatever other searches, that electronic searches she's doing on her computer. This is what they think proves everything.
Software that parses through data. Most people know it for cell phones. There is a branch that does computers, but it's mostly known for cell phones, extracting data and also parsing that data out.
What about Magnet?
Magnet's the same thing. So Magnet is also another proprietary company. They have software, imaging software. They mainly focus on computers. They can do some cell phone stuff, but they primarily focus on computers.
To be certified in Celebrate and Magnet, did you have to take classes and pass exams?
Yeah, so my forensic computer classes certification is probably like a 6-month-long process. It's 2 weeks of schooling down in Florida. Is then a one-on-one peer review for 4 months, practicals of different file systems and computers. Once you get through that, it then is a practical exam. And then once you pass the practical, it turns into a written exam.
Did you have an opportunity to examine the extraction of a Surface Pro that was seized from 47 Summer Street in Duxbury on or about September 16th, 2025?
I did.
And to be clear, the Surface Pro was seized from 47 Duxbury Street in 2023. It was in 2025 that you examined the extraction, correct?
That is correct. I was provided those files.
And what is an extraction?
So these are actually, it's a computer image. Extractions usually typically referred to as cell phones. So this is a computer image. So this was an actual EO1 file, which is an in-case forensic file. So what it does is it copies out the bit for bit data on the particular drive that you targeted at. And then the in-case file sort of compresses the forensic image. It also adds some metadata to it. You can type in like case files. It keeps some integrity to it.
So is it basically you take a computer or a cell phone and you make an exact copy of the data that's on that cell phone or computer?
Yes. Computers, yes. Cell phones, no.
I mean,
But you were working on it.
she can't let anyone just testify. She can't even let the forensic experts, the cybercrime unit guy, explain for himself what the software that he's the one trained on does. She's got a lead even for that. You know? Okay.
Computer or Surface Pro.
Correct.
And so the extraction for the Surface Pro would be the extraction would be a copy of the data that was on the Surface Pro.
Yeah, so the image in this case is a bit-for-bit copy of that drive.
And when you do the extraction or when you view the extraction, are you changing any of the data?
No, that's why we use these types of images, so we don't touch the actual data on that computer.
Did your initial review of the extraction show a visit to a website entitled Suicide Methods on August 23rd, 2022?
It did.
Were you recently asked to look at that visit to that site to get a better understanding of how that website was accessed?
That is correct.
And how did you approach that?
I set a parameter. I went to that artifact that I had previously tagged when I did the initial
What's this
analysis.
Let me
And
just
then-
stop you there.
Sorry.
What's an artifact and what is a tagging?
So an artifact is every single piece of data on that computer is an artifact. So a computer could have 500,000 artifacts, let's say. That's a low end, but as an example. So tagging would be something you would flag that one particular evidence, that one particular artifact as evidence.
So in this case, the artifact was the visit to the website, is that correct?
Correct.
And then the tagging was just so that you could find it when you went back into the extraction looking for it?
Yes, correct.
And so if you could continue telling us about how you approach that.
So I set a parameter of 12 hours before the visit and then 12 hours after the visit, and looked at the correlating other digital artifacts related to that.
And can you tell us what's a Chrome history database?
So that's a database essentially, this is a very slimmed down version of what this is. So if you think of an Excel sheet, and each Excel page is a section of the database. So the database would be the whole thing. And there's a scheme or like a roadmap, let's say, of how these pages interlink with each other. That would be an entire database. Everything pretty much has databases. It's just easy for file expansion and disk saving space and things of that nature.
And what about Chrome Web History Table?
So a table would essentially be the Excel sheet that I explained before. It's a portion of the entire database. That particular one captures, without being a database engineer for Google, who created it, but that table tracks URLs, web page titles, dates and times.
So is it basically a table that you get from the extraction that shows which websites that computer has visited?
Correct. Each table has its own functions on different data it tracks, and then eventually it puts it all together.
And what about a Chrome Web Visits table?
So the visits table tracks things of where the web pages synced to the device, were they local to the device, are they typed, was it generated, was it gone there through a hyperlink?
So basically, is it a table telling how each website was accessed, whether someone typed in a search for it or clicked a link?
Correct.
And you mentioned a couple different ways: typed, linked, generated. So typed would just be someone typing in the search bar something to search?
Yeah, so typed could be a few different things. So typed would be somebody typed in an exact phrase or word. It also could flag the typed version, a typed flag if you copied and pasted something into the URL address bar.
So if you're looking at a recipe for, say, cookies, and you copied cookies and pasted it into the search bar, would that be considered a typed event?
Yes, correct.
Or if you just typed cookies, that would be a typed event.
Or cookies, or if you typed in, say you put CO for cookies, and then Chrome tried to auto-populate what they think you want to type, that would also create a typed event as well.
And then you mentioned linked. What is a linked access?
Link would be that you clicked on a hyperlink, which brought you to a different page.
And what is a hyperlink?
That would be it's a word phrasing, and then behind the word phrasing, there is a website coded behind that.
Is that like when you go on a website and there are certain words that are underlined that you can click on and it will take you to another page?
Yes, correct.
Okay. What about generated?
Generated is something that Google would suggest, Chrome would suggest.
Now, what is the Wayback Machine?
The Wayback Machine is a website that is it's I don't say monitored. It's created and maintained by the Internet Archive as a company. It's a 501(c) nonprofit. And what that does is it goes out on the internet. It takes snapshots of the internet web pages all over the entire internet and then archives that. So you can go back in later. It started like in the mid 90s or so, but you can go back to pick a date, pick a year, and you can see what that website looked like at that time, or approximately. It doesn't copy minute for minute, day for day, but you'll get something around the time that you were looking for of what a particular page looked like at that day and time you want to see.
So with regard to this case and looking into how that site, Suicide Methods, was accessed, what did you learn? Or what did you see?
When I went back?
Yeah, so go ahead.
So I saw, the first thing I saw was a Facebook visit at 9:40 that morning.
9:40 a.m. on August 23rd, 2022?
Correct.
And what was the Facebook?
It was, the link was lynn.say. I believe it was 968.
So Lindsay with a dot in between the D and the S, 969?
969, correct.
And after the visit to the Lindsay.969 Facebook page, what happened next?
There was a search in Spotify music for the singer Tom Hall.
What time was that at?
It was shortly after.
Is your memory exhausted?
Yes.
Do you have your report with
I do.
you? With permission?
So if there's anybody out there who hasn't been watching this trial through and through, the defense was able to, when Patrick was on the stand and they asked about this search, they were able to establish that this musician that they're talking about committed suicide. And that might have been a link from that page over is how Patrick ended up actually doing this search. So if he's able to establish that's not the case, maybe the defense loses a little credibility. But at the end of the day, to Nick Pepper's issue, a severely depressed woman searched for methods of suicide. I mean, okay, but I can't remember. There might have been something else to it. So let's see how it plays out.
That was at 9:42.
So approximately 2 minutes after the Facebook account was accessed?
Correct.
I agree.
And that website, was that a Wikipedia page?
No, that was Spotify.
Oh, I'm sorry,
music.
Spotify music. And then what did you see next?
There was a song off of that search in Spotify.
Was that That's How I Got to Memphis song?
Yes.
And was that at 9:44 and 18 seconds a.m.?
Yes.
Then what happened next?
There was a Google search for Tom Hall.
And was that at 9:44 and 30 seconds a.m.?
Yes.
And what did you learn from that Google search?
Off of that Google search, there was the Wikipedia page for Tom Hall was visited.
And were you able to use the Wayback website to see what that Tom Hall page on Wikipedia looked like around the time of August 23rd, 2022?
I did.
Is this a copy of that Wikipedia page from the Wayback Machine?
Yes.
We can have this marked as the next exhibit.
No objection.
All right.
I have no objection to any of the documents.
This is Tom T. Hall.
Tom Hall, yes.
All right, that may be. Thank you.
Could you see what happened next once the Wikipedia page for Tom Hall was visited?
So I saw there was an anchor on the URL to the death section.
What does that mean, an anchor to the death section?
So an anchor would be put at
Other
the end of a
ASPDA that wears.
URL, so a web address. So what an anchor does, it's a pound sign followed by a section of that page. So if you think of it as, say you go on your banking website and it lists like a table of contents and it has login, mortgages, rates. If you click on, let's say, rates, it's going to jump all the way down to that page, just to that section. So it's a table of contents that's going to direct you directly to a certain section of the web page.
And so on the Wikipedia, someone clicked on death and it brought them down to that portion?
Correct.
And in the death section, could you tell what happened once the person was in that area of the webpage?
Yes.
What happened there?
So in the description that described, the Wikipedia page described of Tom Hall's death, there was some wording regarding a shooting related to his ultimate suicide. Go ahead.
Showing you what's been marked as 232. This portion here under death where it's self-inflicted gunshot wound to the head is underlined. Is that the portion you're referring to?
Yes, correct.
And that portion there with the underlining, is that what you were describing earlier as a hyperlink that you can click and it takes you somewhere else?
Yeah, so inside that phrasing, there's actually a URL behind that with an anchor as well.
Now, something like that, that type of hyperlink, can you hover over that with the arrow that the mouse directs, hover over that and automatically be taken to that site? Or do you actually have to click on that link?
No, you would have to click on that phrase with the link behind it.
And so, based on your examination of the Surface Pro in that area, was the hyperlink clicked on?
Yes.
And where did the hyperlink bring the person?
We now got to the original artifact I had located, which was the Wikipedia suicide method, but it directed it directly to the shooting section of that page.
Could you tell?
So you're
how
explaining
long
you were
the
wrong?
person spent on that page, the suicide methods page, or how long it was accessed?
No.
Was could you tell what time it was accessed?
Yes.
What time was that?
I don't recall the specific time.
Want to look at your report?
This is not helpful in any way. I mean, let's just see what happens, I guess.
At 9:45 a.m.
So 9:45 a.m. The suicide methods page was accessed. Is that
Correct.
And did you use the Wayback Machine to see what it would look like on August 23rd?
I know she's not trying to say, and that's when the plan was hatched. The whole plan to fake everything, to start this, all building up to sending her husband off for 20 minutes so she could kill her children. I know that is not what this Commonwealth is trying to do right now. That would just be absurd. Is that what's happening? Is that what's happening? All right, let's just wait. That better not be. If that's what's happening, they need to be literally stripped of their titles now and disbarred altogether. No more practicing of law.
2023.
I did.
Is this a copy of what you produced?
Yes.
We could have this marked as the next exhibit.
That may be admitted.
233.
Thank you.
And what
This
did you
is an
see
August.
happening when, from that page?
I observed after that another Wikipedia page that went to the Grafton Bridge.
And was that from a hyperlink within the suicide methods page?
Yes.
Showing you page 8 of exhibit 233.
Oh my lord. That's not what's happening. No. No. See?
Within this jumping section is where there was the hyperlink to that bridge.
It's like, what are you fucking talking about and why? Because look, guys, to me, as far it was a long game. Long game. She had to sprinkle some breadcrumbs from the first two children, birth of her first two children, or at least of the second child. But look, to me, as far as I'm concerned, because again, the law is very, very strict on how you have to prove that you could not conform your body. Hence the reading of the complaint. Out of her control, acting on someone else's commands. Body didn't feel like she had control of it. It's very, very difficult, okay? Every time the Commonwealth takes some huge leap, and just stretches things to the most absurd, it just helps the defense. It's just like, all right, that was some bullshit what they did there and what they did there, and oh my God. Oh my gosh. Now that I'm reading this, the jumping from a dangerous location. Oh God, you guys, she's doing it. She's doing it. That is what they're doing. All right, let's just keep it going. Here we go.
Correct.
Here,
Yes.
Grafton Bridge. So again,
Oh,
the person
no.
had to click on that hyperlink to access
You
Grafton
knew
Bridge.
she lived?
Yes, that would be correct.
Now, you said that the suicide methods page was accessed at 9:45 a.m. What time was the Grafton Bridge web page accessed?
That was shortly after that.
Do you want to look at your report?
At 9:48.
9:48?
Correct.
And so approximately 3 minutes after first accessing the suicide methods page, the hyperlink for the Grafton Bridge is clicked.
Correct.
Was there any other activity besides going to the suicide methods page and then the Grafton Bridge page? Any other activity that you saw within those 3 minutes?
Long
I did not
time.
know.
And so did you do the Wayback Machine again for the Grafton Bridge?
I did.
What's it? This is so
This is
stupid.
a very accurate copy of
This
that.
is just so stupid.
Yes.
We can have this marked as Exhibit 234,
Right.
please.
That may be admitted.
Exhibit 234.
I mean, seriously, I honestly think that this is the most absurd thing I've ever seen in the court of law.
You're not able to tell who's actually at the computer doing all of this, correct?
No.
You can only see what data there is
He's
and
wrapping
what's
up.
been accessed, correct?
Correct.
Thank you.
Shame on you.
All right, Ms. Reddington.
Shame.
That's it?
Yes.
That's
Like,
your testimony? That's why you're here today, to talk about a search that was involving Tom Hall, or Tim Hall?
Sustained, if you could,
So I apologize. Your testimony today is based on that search on August 23rd, right?
Correct.
Of 22, right? And you were working as a state police officer back then, right?
Yes, sir.
And were you attached to the Plymouth County DA's office, or were you working somewhere else?
I was assigned to the cybercrime unit.
And the cybercrime unit works with the DA's office in Plymouth?
The cybercrime unit's its own independent statewide unit.
So in the sense that you're independent, it's still the district attorney and his assistant DAs that would reach out to the cybercrime unit and ask for help, right?
Or it could be the troopers assigned to the state police detective unit.
Oh,
Joshua
bullshit. Who
McKelligan.
called you here?
He was the lead investigator on
spit
this
it out.
case, right?
I assume so.
Okay. So you were tasked to analyze the computer, the Surface Pro computer, right?
Yes, correct.
And by all accounts, that was owned by Pat Clancy. Is that correct?
That is correct.
And it was located in his office, right?
I don't know where it was located.
Okay. It's fair to say that when you analyzed the computer back in October of 2025, it was an investigatory role that you were using to locate potential evidence, right?
Correct.
And what is it you were looking for?
I was provided a search warrant with search terms, and that's as far as I knew of the case.
And what were the search terms?
I don't recall specifically, but they were spelled out in the search warrant.
So when you have search terms, you take a person's computer, and then what do? You access it through a device?
So I was provided the images. I never saw the physical computer.
So when you got the images, you were able to load them up onto your computer, I imagine?
Yes, we'll use a tool to help parse through that data. Correct.
And then as a result of that, you were able to plug in words that you could search for, right?
Yes.
For example, like suicide?
Suicide would be one.
Drugs?
I mean, I don't think that pertained in this case, but
Well,
that
yeah,
you could
believe me,
search.
it did.
That I don't recall the specific terms in the search warrant.
Okay. So after you did your search for whatever it is that you were looking for, suicide and other, you're unable to tell us what else you look for, but in any event, you came across this entry on August 23rd, and you indicated that the time frame that you're dealing with on that computer, the Surface Pro computer, was 9:40 in the morning. Is that right?
Can you rephrase that?
Yeah. You can look at your report too. I mean, if you have documents in front of you, do you have?
I do.
All right, so you can take a look at it. You have a document that's captioned matching results. Is that right?
I do not have that in front of me, but yes.
And would that be the search that you conducted?
Is that the magnet tool report?
I don't know what it is. And I get surgery and I can have it seen, so it's just, what is that?
This is the main page of the forensic tool.
Okay. And looking at the main page of the forensic tool, does it indicate the date is August 23rd?
That's in the inbox. This also doesn't. Which, are we talking about this highlight here?
Yeah, but what does that indicate?
That's an inbox. That's not that.
All right, so what time?
Cooper, could you keep your voice up or make sure you speak to that microphone?
So that highlight is a veiled inbox.
Okay. And that would be the HTTPS. And then underneath that, it makes reference to at some point that you were able to see that Lindsay or Lynn's Facebook account was accessed. And it wasn't even the account, it was actually the homepage, right?
Correct. It navigated to the Facebook person's account.
Okay. So that would tell us that that particular Facebook account was accessed, and then that conducted the search. You just testified?
No,
At the next thing.
absolutely not.
This here does not have Facebook, does it?
All right. How about this next one? Does that have the Facebook visit?
This one does, yes, correct.
You both want to take a look.
Both of us.
I have both of us. Blind.
Yes, that'd be right.
It's
yeah.
All
adorable.
right. Thank you. Now, just before I leave, above that, does that also indicate like these two top lines?
That would be that was a CNBC web visit, which was typed in. And then there's access to a Google Gmail account.
And whose
Inbox.
Google Gmail account was that?
That I don't know.
Because those two lines and references to the Google account were not in your report, right? You started off with the Facebook search, if you will.
Yes.
So you started off with Lindsay Facebook that was signed into the homepage on Patrick Clancy's Surface Pro computer, right?
So my tool report has all of the artifacts tagged as evidence.
Okay. So when you tag the actual data from the Surface Pro and the HP laptop as well, right?
Yes, correct.
And your October report back in was it 25 or was it 22?
25.
So, but nothing changes on the computers. I mean, whatever your searches are and your records don't change over the years, right?
No, as long as it's preserved in that state and the images of that computer will remain the same.
Okay, so, and it's fair to say that with this investigation, obviously happening back in 2022, that the computers were hermetically sealed and stuck somewhere with an evidence locker to make sure that they're preserved, right?
Yes, that would be best practice. That would be correct.
So then in October of 25, the district attorney's office asked you to conduct a search of the computer, apparently. Is that right?
The trooper in the Plymouth State Police Detective Unit reached out.
And that would be McKelligan, right?
No, it was not.
Okay, do you know who it was?
Trooper Justin Paul.
Justin Paul.
Correct.
Okay.
Paul.
And as a result of that, you then went.
Good old Trooper Paul. Was he pirouetting? Was he standing on his head? Did he do any acrobats whatsoever? And if you know, you know. And I'm pretty sure everybody knows.
Prepared your report. And one of the things that you did is you noted that on August 23rd of 2022,
Paul. I'll be like, oh.
at 9:40 and 08 seconds, that there was an access to the Lindsay Facebook account, right?
Oh, there was a visit to that page, correct.
Right. And then that page continued on to look for Tom Hall and
Is it a different
Walking to Memphis or whatever in the songs, right?
Yes.
On Spotify?
Yeah, the song. Yes, after that was a Spotify.
And then the time frame of that would be that he went and went to a hyperlink that took him to methods of suicide. Is that correct?
That is correct.
Now, were there any searches on that computer for example, ways to kill?
No, there was not.
To your knowledge, and I understand that you might be stuck with what you investigated, but are you aware that there were any searches from
This is the
Lindsay
best you
Clancy
got.
or Patrick Clancy on ways to kill? You ever heard that?
In my initial report back in October, that contains all of the evidence artifacts that I had tagged as evidence and provided, I did not come across it. No.
Right.
Me too.
So basically, what
I'm
you
going with it.
leaving with
I
the
did.
jury would be that on that date of August 23rd, at approximately 9:40 in the morning, and then carrying forward with jumping from Tom Hall to the Wikipedia account to the underlined
Come on.
name,
Right, T-Bird?
suicide, jumping to that page. That all occurred between 9:40 and say 10 o'clock in the morning, right?
Correct.
They are
Did you know,
so
sir,
stupid.
that on August 23rd, prior to your report,
I just have to keep going about it. They are so stupid. And I'm sorry, but they are. The Commonwealth, these prosecutors. First of all, this entire thing is the most ridiculous theory we've ever heard, right? It's all a reach. It's a stretch. It's nonsensical. It's just nonsense. Forget the ickle. But not only that, it's not even true. Like, not even the person who did the searching. Their evidence does not suggest that she actually did the searches in the first place. And then you use Patrick's search to make this ridiculous theory. Oh my gosh, what is wrong with these people? There's literally something wrong with them. All right, blooping back.
Did you know, sir, that on August 23rd, prior to your report indicating the Facebook account, that Mr. Clancy signed in, and it was Mr. Clancy's email that accessed the Facebook account for Lindsay Clancy?
I did not.
And that was not included in your report, was it?
No, it was not.
And you know that the Clancys had 3 children, right?
I did not.
Well, you know that you were working on a case where Lindsay Clancy was the mother, and she was married to Patrick Clancy, right?
Correct.
And did you know, sir, that on August 23rd of 2022, that
Lindsay was a
2-year-old child was brought by Lindsay to South Shore Health for Dawson's ear recheck, that he had problems with congestion, but no complaints of ear pain, no fever. And that was on August 23rd, 2022, that he was examined at 10:15 in the morning.
I'm not privy to those
Oh my
facts.
gosh. What in the actual
So you don't know that.
fuck? She wasn't even home, people. She wasn't even home. I'm trying not to scream. I'm sorry, because I know some of you don't like it, and it is loud. I just can't help myself. Maybe I should turn down my mic so I can scream better. I don't know. She wasn't even home. She was at a doctor's appointment. They need to be disbarred. They need to be disbarred. There needs to be punishment for this. This is the kind of shit we saw it in the Karen Reed case to the nth degree. This is the kind of bullshit that they should not be allowed to get into a court of law. This is why we need to revamp the rules of evidence, because you know what? These fucking people can't be trusted. They cannot be trusted with the power they have been given. And the stupid story is a stupid story anyway. No one's buying it, lady. Even if she was home, even if she did the search, even if it was her computer. This is an outrage. Okay. Moving on.
Those facts.
Yeah, of course you were.
So you don't know that Patrick Clancy's email signed into Lindsay Clancy's Facebook account. You're not aware of that, right?
Jeez.
It's whatever the default profile was signed into the Chrome browser.
And then that accessed the Facebook account, which looked up Tom Hall, the singer, right?
Yes, correct.
That then led to the Wikipedia talking about suicide.
That is correct.
Led to the Spotify talking about somewhere in Memphis, whatever the song was, right?
Yes.
And this was all occurring from 9:40 in the morning until, like I said, 10 o'clock thereabouts, right?
That's correct.
You tagged actual data from the Surface Pro as well as the HP laptop, right?
I did.
And your October report contained searches from the Surface Pro, right?
Yes.
And you recall, for example, just a representative sample that, and this would be on the Surface Pro computer. Now we're jumping ahead to December 5, not August of 22, December of 22. One of the inquiries of the Google searches was what to do when a psychiatrist overprescribed, right?
Yes.
Searches for medications, right?
Yes.
Including Lamictal, right?
Correct.
Can bipolar disorder be temporary, right?
Yes.
Can benzos reveal bipolar disorder, right?
Yes.
How long are detox programs, right?
Yes.
What is DBT? I'm just saying that's a search. I don't know.
Oh, yeah.
May know,
I had to
may
look
not.
that one up too.
Okay. Lamictal
GMT,
versus
someone
Zola. It
mentioned
says
yesterday.
Zolafy, but I would suggest it would be Zoloft. That was a search, right?
Yes, correct.
What is mania? It was a search, right?
Yes.
Ketamine for benzo withdrawal. January 18th of 2023 was a search, right?
Yes.
Ketamine therapy on January 18th of 2023, correct?
Yes.
Now, you know, maybe not personally, but you know Steve Verino, who's also a gentleman who does what you do with computers and laptops and stuff, right?
Yes.
Now, you've worked on cases, and you know Steve, you recognize him right here, right?
Yes.
You know that Steve was working with me and Lindsay on accessing information from cell phones and computers, and he actually, through me, reached out about a month ago to the DA's office and raised some questions, correct?
I'm not privy to that.
Oh, well, the DA reached out to you about a month ago and asked you to revisit your investigation, and as a result of that, you created another report, didn't you?
I did.
Wow.
And that would just
No.
be on July 26th of 26, right?
Yes.
And that was after the
Diabolical
DA
is
reached out
right.
to you, but didn't tell you it was because
Diabolical.
we had questions that Mr. Verino asked me to find out about, right?
Yes, I was not
Thanks,
privy
Mary
to that.
Blues.
So as a result of dealing with the DA in July 26th of 26, you then prepared your report, and the purpose of that report was to find out more details, if you could, pertaining to the, quote, methods of suicide page, right?
Correct.
And in your July 26th report, you then went into detail about your findings, correct?
Yes.
And we would agree that that particular webpage was not a search for methods of suicide. It was actually the Tom Hall and the music, right?
That is correct.
And then the URL shows access to Lindsay's Facebook profile, correct? You accessed and found out that Lindsay's Facebook profile
Was a web visit.
right.
Yes, correct.
But you don't know that it was Lindsay that was actually using that computer to search for Tom Hall, right?
I don't know who was sitting behind that.
You don't know that Patrick Clancy plays the guitar, do you?
I do not.
You don't know that Patrick Clancy is a music aficionado, right?
I do not.
You don't know that Patrick Clancy enjoyed Tom Hall music, do you?
I do not know that.
And you certainly don't want to leave it with this jury that Lindsay was looking up ways to commit suicide in August of 22, do you?
All I'm presenting is the facts that were presented in front of me.
Wow. That was amazing.
And it was a couple more questions, sir. When a user logs into their own Facebook account, it doesn't populate or bring you directly to the actual profile page. It brings you to the home page, right? That shows your followers and things like that.
I think so. I don't have Facebook or social media, so
All right.
maybe, I don't know.
That's all I have for this gentleman, Your Honor.
Now, what are you going to get back up there and say?
Come
Go
on,
ahead.
I would ask if I could, Judge, the two documents that I was questioning him from, could I introduce those into evidence?
So
I
I
think
guess
he
if we ever get
agreed
in
that
trouble
that was part of
here,
the
you're
search.
not going to be able to tell who's on what. I got Bob's, YouTube. Really, it's the only thing I have, though. But if he had ever logged in on my computer from Facebook, I would have never logged out. And if I got taken to Facebook, that's what I'd use. Because I just use whatever's there. If all I'm doing is looking at information. Wait, what prompted this? Let me just see. Oh, she's asking for it.
Can we just approach?
Sure, yeah.
Records from the PD. Your Honor, I would offer, if I could, the medical records from the pediatrics associates that,
They're already in evidence.
well, I'd like to have it focused on that. You don't mind if we put that.
What we mark that for identification, we can address whether or not, I want to double check. I haven't gone through all the records either.
You son of a bitch.
We'll mark that for identification.
She wasn't even home. Well, there's the bow. There it is
Thank
down
you.
there. She wasn't even home.
For identification.
Sir, just for clarification, before when I was doing direct, if at any point I said August 23rd, 2023, what you did when you did the Wayback Machine was searches for around the time period of August 22nd, 2022, correct?
Correct.
And anything that you
Not
looked at that
intentionally.
day regarding the search
did
for
say
suicide
that.
methods or any of the other places that were visited were August 23rd, 2022, correct?
Correct. 2022.
And the visit to the Grafton Bridge Wikipedia page was at 9:48 a.m., correct? Not 10 a.m.?
Wait. All right, leading. And now I need clarification. Was the doctor's visit 2023? Because now I'm confused. What was the 2023? Was she home? Oh God. Look, I watched the and now the time now I got the time wrong. Everything's wrong. So she either because of the time or the year, I don't know, but now I'm just wondering the year. Was the doctor's appointment the same year? For God's sakes. But now let's get to the time.
That visit was at 9:48. Correct.
Okay. And defense counsel asked you about the
9:48.
defendant being at the doctor's at 10:15 a.m. Are you aware that it only takes 4 minutes to drive from her home at 47 Summer Street in Duxbury to the Kingston location of the pediatrics?
I was not, and I also wasn't aware that they went to the doctors.
And
And then how long do you wait until you are seen? I mean, it only takes 4 minutes to get to the doctor's office. I wouldn't know when the appointment was. Because I guarantee it wasn't set for 10:15.
you can't tell us who was behind the computer at different times, correct?
No.
You can't tell us whether people used the computer, then got up and let someone else use it, and then went back to using it, correct?
No, you cannot.
You can only show us the data that you observed that day, correct?
That is it. Yes.
Okay, thank you.
You know what? Shut up. That's what I got to say to you. Shut the F up.
What has been marked for P for identification, which would constitute the health information records from the South Shore Health
Show her appointment was.
pertinent to the child.
Sure, there's an arrival time.
You're aware, sir, that the records, or you're aware, sir, you're not aware that the child was brought to the doctors not at 10:15, but was brought to the doctors around 10 o'clock in the morning. You aware
I'm
of that?
not aware of any of that.
And did you
on,
know
lady.
how old the child was?
Sir, my testimony is related to the.
So you don't? The
computer.
answer is
I
no?
do not. No.
Okay. So is it fair to say, sir, that, I mean, from your life experience, that when someone has to bring a child, a young baby to a doctor, you got to get them dressed, you got to feed them, you got to get in the car, you got to drive? And that's the
A lot more than
4-minute
4
ride
minutes.
as well, right?
I'm not privy to any of that information.
Thank you.
All right. Anything further?
No.
All right, thank you, sir. You may sit down.
See,
Thank you.
again, going to you guys have no kids. It's like you don't even know anybody who has any kids because abso-fucking-lutely. And if the appointment is at 10, you get there a little bit before. And if you're talking about a baby, there are all those steps he just described. You know, no matter what, let's say she got everything done early. You know, you still don't have that time to be fucking around on the computer. I thought he said that the people were on the computer from, X time all the way up until 10 o'clock. What in the actual fuck? Go back to whatever fucking hole you crawled out of. Like you are awful, horrible human beings. Oh, Rosemary's leaving. Wow. See? Now, look, here's the thing.
Chiapini?
That also tells you, that's something that they were, wanted to see play out. Look, it could also say that was the only minute she had available and she wanted to leave after the witness, but seems like she wanted to hear that testimony. Talk about closing on a dud. Ending on a dud. Bob says they got 3 more witnesses and they're done.
Attorney Sprague, please.
Thank you. Good morning. Can you please state and spell your name for the
Go
record?
to breakfast with
My
Cameron.
name is Timothy
with Ken's
Chiapini.
early.
Last name is spelled Chia, P as in Peter, P as in Peter,
He's so
I-N-I.
wonderful.
Where do you
Yeah.
work?
I work for the Commonwealth of Massachusetts for the Department of State Police.
How long have you worked for the state police?
I graduated the Academy in March of 2012.
What is your current assignment?
I am currently the unit commander for the Critical Incident Technical Investigations Team
How long have you been doing that?
since approximately April of this year.
What was your assignment in January of 2023?
I was assigned to the State Police Detective Unit for the Plymouth County District Attorney's Office.
Do you have specialized training in cell phone forensics?
I do.
And could you describe that, please?
I was initially certified as a Celebrite physical operator and a Celebrite certified operator, Celebrite certified physical analyst in March of 2017.
And are you also trained in gray key and magnet?
I have been trained in gray key examination since August of 2021, and I've been familiar with the forensic program known as Axiom in that course, but I'm not certified in Axiom.
And regarding Celebrite, can you describe that software for us?
Celebrite is a forensic access and acquisition tool for cell phone or mobile device forensic extractions. It also has an analysis component as well.
And were you asked to do a forensic analysis on a cell phone belonging to Lindsay Clancy in 2023? Oh, I'm sorry.
Yes, ma'am. Celebrite is an access and acquisition tool for mobile device forensics and cell phone extractions. It also has an analysis component for extractions.
And were you asked to do a forensic analysis on a cell phone belonging to Lindsay Clancy in 2023?
I was.
Did you do that?
I did.
And how did you do that?
I performed an advanced logical extraction on the iPhone device belonging to Lindsay Clancy.
Can you tell us what that means in just lay terms that we could all understand?
An advanced logical extraction of an iPhone is essentially an iTunes backup. It is the information or data from the phone that you as a user can see, including images, calls, text messages, browser artifacts, basically everything that the person would see that uses an iPhone.
And is it just making a copy of everything that you could see on that phone?
That's correct.
And what is the analysis portion of, you mentioned you do Celebrite extraction and Celebrite analysis. What's the analysis portion?
In January of 2023, the analysis software would be Celebrite Physical Analyzer. And with that, you can also export a report to be utilized in Celebrite Reader.
So basically, are you just taking someone's phone, making a copy of the data that's on it, and then looking through the data?
That's correct.
Is it an exact copy?
Yes. When the phone is forensically extracted by the Celebrite software, a hash value is created. A hash value is a unique digital fingerprint of the extraction. It's an alphanumeric string of characters. And every time the extraction is opened in the Celebrite software, that hash value is verified. If the data in the extraction is changed by just 1 bit, the hash value would be changed and the extraction will no longer be valid.
So basically, you look at those numbers, the number chain, to make sure they're the same, and then you know it's an exact copy?
That's correct.
And did you do that in this case?
I did.
And was it an exact copy?
It was.
And are you able on the extraction to change any of the data while you're analyzing it?
No. That would invalidate the hash. I can use filters in the analysis to look at particular data that I want, but I can never change the contents of the extraction.
And so when you say use different filters, can you put things in categories to organize it so that, for example, can you put all the photos together and all the text messages together?
The Celebrite Physical Analyzer tool automatically parses the data into various categories. and it processes media, various forms of media, images, videos. It processes different direct communication, whether it be through a web application such as Instagram or the native messaging application on the device known as iMessage. So it parses the information automatically, and you're allowed to look at different categories.
So does it create a report with all the data?
I can create a report from the extraction, and it has all the data contained in the report, and I can filter it based on the parameters that I'm allowed to look at legally.
And when you do that extraction of a phone, do you get everything that's on the phone?
Depending on the type of extraction, I get all the data that's available to me by the forensic tool that I'm using at the time.
So do forensic tools improve over time to allow examiners to get more and more data from phones?
Yes.
So basically, what you were able to get from Ms. Clancy's phone was what the tool you were using at the time was capable of getting at that time.
I performed the most comprehensive extraction type that I was able to do at the time.
Made a funny that worked because I didn't have the troopers mixed up. What I said was, and do sometimes these forensic software tools make changes to their software in the middle of a trial so that the evidence can appear, one way or another. Is that something they also do? If you know, you know, and you all know.
The examination.
And then there were improvements to that system following what you did that may have allowed other examiners to get more information.
That's correct.
Were you asked to generate some reports about certain sections of the defendant's phone?
I was.
We could pull up the...
Oh, gosh.
Could look at the screen, please. Were you able to create a report regarding data on Ms. Clancy's phone from November of 2022 to December of 2022?
Yes.
Can you zoom in on that, please? And could you just explain for us the different columns we're seeing here?
The columns are automatically generated by the software when you create a supplemental report. This is a supplemental report created through the Celebrate Physical Analyzer software analysis tool. When you create the supplemental report, you can stipulate to certain parameters, certain content, certain timeframes based on your investigation. In this case, there are multiple columns at the top reflecting the different types of data, the timestamp for that data, a description in the source file for the data. This is a timeline report, and therefore it reflects those exact columns, and that is predetermined by the software.
So for example, where it says type, what is that telling us?
That's where Celebrate has parsed the data and categorized it based on the forensic extraction.
So there at number 1, where it says activity sensitive data, what is that?
That would be the data from the health database within the phone.
If there was something in the direction box, what is direction?
Direction could be related to a call incoming to the device or outgoing from the device.
So if one was a phone call, it would say to or from?
I believe the exact categorization would be incoming or outgoing.
Incoming or outgoing, okay. And then the attachment box?
Attachment box would be associated with a message, typically a MMS message or multimedia message. A text message that contains a photo would be listed as an attachment. It could also be associated with an email that has an attachment or some type of transaction on the phone that resulted in something being attributed as an attachment.
And then what about the location box?
If the data source has location information associated with it, then that box would have data filled out this report is 768 pages, so there's a variety of sources of data within this report.
And what about timestamp? Where it says timestamp, the date and time, is that Eastern Standard Time?
It is, it's UTC -5 as the time of this search warrant, the time frame of this incident occurred in January of 2023. Therefore, the extraction reflects the exact time frame of the time zone of the device at the time of the extraction.
And where it says party, what would be in that column?
Again, this is a timeline report. Therefore, there's a variety of data sources contained within it. There is chats or messages that occur from the user of the device to other people, and those parties would be listed within the chat, otherwise known as a group message.
So if it was a text message, the direction would say incoming or outgoing, and the party would say who the text was to or from?
It would say who the participants are in the conversation.
So if it's one person you're texting, it would have that person's name, but if you're in a group text, it would have all of the names?
Correct.
And then what about the description box?
Description box is based on the database information.
She's sending happy
it has some information associated with the actual.
Are we about to get to like she sent happy texts? Look, she was happy. She talked in groups. I mean, I'm trying to predict where this is going because I need to fill the time. You know,
Data that was parsed by Celebrate. It also provides the source file. The source file is the database that Celebrate parsed the data from. Everything that you see as far as activity sensor data or any other categorizations, that's done by the software. The software parses that data to make it more readable for the examiner, but everything is associated with an actual database within the device.
And so, for example, where it says source health, that's coming from the health section of the phone.
Specifically the health database, Health DB.
I'm just
And
so
where it says source file, Lindsay's, how does that name populate there?
I'm just so discombobulated with what the prosecution's doing today. Is that what we're getting to finally? Is the phone call, the answering of the phone call, the making of the phone calls? I'd like to know how many pharmacies she called. Somebody said she called around to pharmacies to find one that had it. So I'd like to know how many pharmacies she's called. And someone please tell me. I mean, in my closing, I would be standing up and saying, please, Lord, please. Why in the hell would a woman she's got a plan, right? It's been premeditated. She already has it. She's premeditated the shit out of it. Call around to find the pharmacy that has the product and send him there instead of sending him to one that doesn't. Instead of saying, you know what? They don't got it. Why don't you go over here?
Source file.
Indicating that it comes from Lindsay's iPhone. That is the name that the software detects from the name of the device when it conducts the extraction.
Where the box for party, if it's a phone call or a text message and it has a person's name in there, say I text you and your name is there, how does that populate? How does your name get into that box? Is it something that the phone gets from incoming information, or is it something that's in my phone?
The tool is only able to take the information that is present on the device at the time. In order for contact to be in a phone, it would have to be entered by the user.
So would it be whatever I name your phone number is what will show up in the party?
Correct.
So if I have, say, my mother's phone number in there and I say mom, for her contact information, it will show up as mom.
The software will show up will display the phone number and the contact name that was detected by the tool from the extraction.
So if I've put a contact in mom and the phone number will show up in mom.
Correct.
Can you search within this PDF?
Yes.
And do you do that by clicking on the search bar there at the top?
Yes, this is Microsoft Edge, and that is the proper method within this.
I didn't even know about that.
And so if we were to search, for example, the plane.
I'm not sure of the spelling.
good. Sometimes it takes a
Oh,
second to
read
populate.
It does. It's a large document. It's, as I said, it's 768 pages. So depending on the machine that you're using to conduct your analysis, it could take some time for the document to load.
Okay, and do you use these arrows here up and down to go to each spot that word is located?
Correct. The application Microsoft Edge has detected.
I know they had it. My point is, why wouldn't you try to find one that didn't have it and send them there? You know, say, oh, they don't have it there. You got to go to this CVS for it and send them to one where they don't have it. I don't know. Whatever.
4 entries for the spelling that is in the search box, and you can navigate to each of those 4 entries by using those arrows.
So for example, here at message 6951, it says it's an instant message. It's outgoing, meaning it's going out from Lindsay's phone.
That's correct.
A different
It's on
ADA,
December
where's the vote?
21st, 2022 at 2:57 p.m., correct?
Yes, Eastern time.
And then it says from Lindsay owner to Allison, correct?
Yes.
So that indicates that it's a text message from Lindsay to someone named Allison, correct?
Yes, with the corresponding phone number.
And then here where it says more of a general depression mental health program like at McLean Hospital, is that the body of the text message that would have been sent from Lindsay's phone to Allison?
Correct.
And you can search through the PDF for whatever term you're looking for, whether it be Patrick or medications or anything that you're searching for. It will populate any text messages or searches about those keywords.
Yes.
Guys.
If we could have the next one, please.
I don't know. We could all talk about causes of nose whistles.
Did you also do a report regarding things that were downloaded onto Ms. Clancy's phone?
Yes.
You can look here. Is this that report?
Yes, again, this is a supplemental report created within the physical analyzer analysis tool from Celebrate.
And what is this report showing us?
A singular item from the documents section of the project tree, or otherwise known as the analysis component of Celebrate Physical Analyzer, and it's one single document.
And do you just, this blue hyperlink here at the top, 2022, 10, 12, 15, 28, is that what you click on to access the document?
Yes, when you create a supplemental report within Physical Analyzer, it when it creates the PDF, if it has an attachment associated with it, that attachment will be in a separate folder within the report. That way, when you click on the actual hyperlink, you're brought to the physical document itself.
And for example, in this report, there was a request for medical leave form that was downloaded to the defendant's phone.
Yes.
If we could go to the next one, please. What are we seeing here in this report from December 26, 2022 to January 24th, 2023? Is this the same type of search for any information and data on the phone during that time period?
Again, a timeline report is a chronological report of a sequence of events on the device, and it has the same categories as the previous exhibit. And in here, the first item within the date parameters happens to be a calendar entry.
And so if we go here to page 846 of the document, can you explain for us here, is this web history, website visits that are documented on the phone?
That's one of the categories listed as an artifact. The items shown here on the screen are all associated with web browsing.
And here where we see 10773 and 10774, and they both state can you treat a sociopath? Those are two entries that have basically the same search term, correct?
Yes.
And that was on January 20th, 2023.
Wow. So yeah, you guys are literally proving the defense's case. This woman is having such horrific thoughts that what, now she's concerned she's a sociopath? She's developed, you know, I just don't know how is can you cure a sociopath showing any sort of premeditation? Like what how out of touch with the fucking people and the world are you, lady?
Yes.
And they both say 8:28-29 p.m. So is it possible to do two searches at the same time, like it is displayed there?
The Celebrate Physical Analyzer tool parses the information in ways that the information can be categorized in a multitude of ways. Simply because there is more than one entry does not mean that something was done more than once. It's simply just a category that Celebrate has identified. You could have an item that's in searched items because that's what the tool has identified as a searched item. Also within web history, as in the search item occurred within the web history, does not necessarily mean that it was done more than once. It's the job of the examiner to be able to look at the timestamps and the associated databases to determine, is this more than one entry or the same action just categorized in multiple ways.
And when reviewing Ms. Clancy's phone, did you see numerous occasions where it looked like something was searched multiple times, but it all had the same exact timestamp?
That's correct.
And so what you just testified to make sure I'm understanding it, would it be accurate to state that one search could be documented and located in many different areas of the phone?
It could be parsed in multiple ways by the analysis tool.
So basically categorized?
Yes.
Correct.
So
Where's
it's
that
one
for?
search that's categorized as multiple different things.
That's possible.
And so here, when we had the search at the same exact time down to the second, that appears to be one search for can you treat a sociopath, not two, correct?
Yes.
We can go to the next one, please.
Yes, Gina.
Now,
That's what I'm
this area
saying.
here,
That is my
the separate report, is this the notes that were found on Ms. Clancy's phone?
That's correct.
And if we could zoom in on that, please. And it's basically detailed in journal form, correct?
Yes.
Starting October 24th, 2022, and moving down, correct?
The summary portion that you just pointed to is automatically generated by the application when it reads the first few lines of text. The more relevant date is in the column to the left.
So over here, where it says created, October 25th, 2022, that's when the note is first created?
That is the date that's detected by the analysis tool from the operating.
I'm sorry. So she's doing all of these things. I'm just so fucking confused. Commonwealth as part of a plan, a plot, a falsity? Is this what you're saying? Because what you're showing us is a woman who is trying everything to gain control over her fucking mental state. Affirmations? Like, what is happening?
System of the device.
What does modified mean?
That's the
When a Motta changes something.
date that was detected by the forensic tool and the last time that this note was modified according to the operating system.
Modified being it was changed in some way?
Yes.
And so if I start a note in my phone on October 25th and I go in there every day and change it, and the last time I change it is November 3rd, will it show every modification or just the last modification?
The only date timestamp that will show is the last modification, unless the forensic tool is able to categorize each time the note was changed. I'm only able to detect the modified timestamp or last modified timestamp and just the entirety of the note.
And excuse me. You don't know how many times this note was modified, correct?
Based on this forensic tool and this artifact, no.
Can you tell what within the note was changed?
I cannot.
So everything could have been the same and maybe a date changed, or there could have just been a date and everything was changed on November 3rd. You just don't know.
There could just been a one character change on the last modified date, but with this forensic tool and this artifact.
What's the date?
November 3rd.
Thank you.
And if we could just scroll down to the October 25th entry. And I would just like you to read this portion of the note. I would read it, I'm sorry, but I'm having some difficulty.
I'm sad and depressed because I am not able to parent my third child like my first. I want to treat any one of my babies like my first, but I know that's not a feasible possibility. I'm sad that I stopped breastfeeding. I feel not as connected with Cal now. I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all my kids. I'm also probably having a bit of an internal conflict because my whole life I wanted to have a lot of kids. I still don't want Cal to be our last, but I have a lot of figuring out to do before I have another. I'm on the fence about starting a new medication for anxiety/depression. I just want to feel happy. I want to be able to relax and take care of my kids. And then when they go to bed at night, I want to deeply relax and hang out with Pat and then fall into a deep sleep for 8 hours, get up and pour hard into myself for an hour and a half. Cal was so very planned and desired. I want to be able to give him all the love he deserves. I guess that's what it's like to be the third child, though. He's not the first third child to ever exist. I think I know he'll be okay, but it's really hard for me. I hate that he has to put himself to sleep. I'm sad I'm not breastfeeding anymore, but I think deep down, these are the right choices.
What is wrong with you idiots?
If you could continue.
As for the sleep training, I needed a baby that slept through the night because I simply do not have the opportunity in my life to catch up on sleep. I just don't. If there was a time for me to nap every day, then that may not have been the case, but there really isn't. When Cal naps, I have to take care of Cora and Dawson. That's just how it is. It feels cruel to me that we did not do that to Cal, but the reality is we did what we had to do. I guess I also feel slightly traumatized by the sleep training, but that feeling was only really present when I was severely sleep deprived and paranoid. I know what we did was the right thing and okay. As for the breastfeeding, it kind of goes hand in hand with the sleep training. Once he started sleeping most of the night, it was then a daily struggle to keep up my milk supply. I was having to take a ton of supplements and constantly think about eating and drinking enough to keep the supply up. And then I was having to think about pumping extra to keep it up. And that was really hard to do with Cora and Dawson around. When I tried to leave Cal to go out with Cora and Dawson, I was stressed about the pumping, and not to mention the fact that Cal was at home and not taking a bottle. So it was a battle of if I should pump or not. I know I did the right thing because I need to be able to leave Cal with someone and get fed. As much as I don't want to leave him, I need to be able to. I need to be able to be present with my other kids. I still really, really want a fourth child, but I need a really good therapist before then. I'm on the fence about starting a new med or not. I want to feel happy, but it would be nice to feel authentically happy and not fake. But I need to feel happier than I did last evening because then I was pretty depressed and not enjoying any of my children. It was really sad. I needed the breastfeeding off of my plate. I'm struggling so hard because I wanted to parent each of my kids like my first, and since I can't, that's depressing to me. This is definitely the root cause of all our problems. Now I feel like I'm not parenting any of my kids the way I want to, and that makes me sad too. But I'm going to try my best today. Things I love doing that help me.
I have to pause here, and I'm sorry, but honestly, the Commonwealth is just they honestly have no social awareness. It's like, what is wrong with you people? Do you think that the rest of the room hears these words and is thinking, Oh, she was tired of those kids. She couldn't stand to be a mother anymore. She was fed up and just couldn't manage it, so she killed them. No one else is hearing that. If that's what you're hearing, you need to look internally, because what the rest of us are hearing is someone who is desperate for that connection, who is desperate to love and be there and care for her kids. Not for a minute does it sound like someone who is just too sick and tired to take care of her kids. She's sick and tired of not feeling like she's giving them every ounce of herself in the way she wants to. This is not someone who wants to get rid of their kids. I honestly, it's like, again, and somebody said it like, who is sitting around this round table coming up with this, like that sounds like what this means.
Things I love doing that help me love and appreciate and enjoy my kids are activities with them. I definitely started having some depression after Cora, but once I started getting up and out with her, I felt much better. I think signing Cal up for baby music class would be a great thing. Maybe Fridays can be my day with him. I've just fallen out of the habit of doing anything fun, anything for myself, anything with Pat, and I need to work on that. On a positive note, I had a great deep night of sleep. I'm terrified of something happening to my kids or doing something wrong to mess up their development. Our generation is inundated with information about every aspect of parenting and everything that go wrong if you don't get it right, and all the scary things happening in the world. It's insane. For the last 5 years, I've just filled my mind with all things parenting, and it's just unhealthy.
Thank you.
Thank you, as though she just made an amazing
And so everything
point.
that you just read would have been written and filled in by the user, correct?
Correct.
Lady, get a fucking clue.
If we could go
Get
to the next one.
fucking clue. Jeez.
This is another note, is that correct?
That's correct.
And this note, it says it was created December 22nd, 2022. And then it was modified on January 23rd, 2023, correct?
Yes.
And this note here, again, we don't know how many
Day
times
before.
it was modified. You just
Modified
know
date.
the last date it was modified, correct?
That's correct.
And you don't know what was changed in the note. You just know that something was.
Correct.
If we could go to the next one.
I agree, Marcia, that this diabolical plan is turning into a blessing because it's really hurting the prosecution.
Now, in this report, we're seeing some photographs. Is that correct?
Yes.
And why did you flag these photographs?
The photographs had multiple modification dates relevant to the investigation.
How so?
Picture of the baby.
The photographs have created, modified, and access date that are all the same.
That's not right.
However, the metadata indicates a much earlier time.
What is metadata?
Metadata is data about data. An image is data. And with the Cellbrite physical analyzer tool, you're able to see the data about, in this case, an image. Metadata would be the device used to capture the image. It would be potentially, based on the user settings, location data associated with the image, where the image was when it was taken, where the device was when the image was taken. A lot of times it'll tell the size of the image or the type of image file that it is.
And so basically, when you look at the metadata of a photograph, you can tell what device was used to take it and the date that the photograph was taken on.
Correct.
And can you also tell if that photograph has been changed or modified in any way and when it was changed?
Using the forensic tool, I can make inferences based on certain modifications.
And how do you do that?
In this case, the image here is a .jpg. That's the file type of this image. therefore, I know that the image that I'm seeing is created, modified, and accessed on this date. However, it has a capture time of November 2nd, 2022 at 11:27:15 a.m.
And is there something on here that says when it was modified?
Where the cursor is now, it indicates the modification date.
So above it is when it was created, below it's when it's modified? Or no, down here, capture time and the metadata is when it was initially created, correct?
Correct. And you look at the source file, you can see the source file indicates that the image was modified under the component where it says adjustments.
So just for the jurors looking at this report, here in the metadata, capture time is when the photo was taken. Above it, the 1/23/23, that's the date that the picture was changed in some way.
Yes.
And are you able to tell how the photograph was changed?
I can do analysis based on an image and see that an image from its native format was modified.
So basically, if I'm on my phone and looking at photos and I brighten something or I crop something, crop someone out of a photo, that would show it as being modified?
Andrea.
It would show it as being modified, and in this instance, it created a new file, which is why it has the created and modified date being the same.
And so would it be accurate to state that on this type of phone, when you modify a photo, you can change that photo and leave it there changed, or you can create a new image with that changed photo?
Well, with an iOS device, Apple has the capability of taking what's known as a live photo. It's a proprietary name with Apple, but the exact file type is HEIC file. HEIC stands for High Efficiency Image Container. HEIC or a live photo is essentially that. It's a container or a burst of images that are taken over a very short period of time. It's a more effective way to store an image file within a device. It takes up less room. It also allows the user to have a multitude of pictures to choose from at a single point in time. If you modify an HEIC image to be a singular photo, you can save it to the file type known as a JPEG or JPG.
So a live photo is one of those photos that's taken and you see a little movement before it settles into the photo when you look at it?
Yes, ma'am.
And is that an automatic setting on iPhones that it's set to live and you have to change it if you don't want that feature?
That's correct.
And so if you modify the photo and save that photo, that modified photo is not live?
Correct.
And is that what you saw here? There were a lot of photographs of the children that were accessed and modified in some way?
Yes.
And during what time frame were these photographs accessed and changed?
During the evening hours of January 23rd, 2023.
Okay, if we could go to the next, please. And what is this report displaying?
This is another timeline report with the first event starting January 24th, 2023 at 4:00 p.m.
And does it go on January 24th, 2023 from 4 p.m. to 8 p.m.?
That's correct. It encompasses everything that would be before that time frame. It appears the last entry is 7:02:01 p.m.
And this would contain all of the things that were done with the phone between 4 and 8 p.m. on January 24th, 2023. Is that correct?
Everything that was detected by the forensic tool based on the extraction type.
Okay. And if we could go to the time frame 4:30 to 4:35. using the tool search Miralax. Looking here, starting at item 37 at 4:46 p.m., is there a search for Miralax for kids on the phone?
Yes.
And again, we're seeing the search for Miralax for kids, 446.55, 446.55, the same time over and over again. Is that another example of one search showing up in multiple categories?
Correct. As an examiner, I would be looking at the timestamp and also the category, second box in from the left, indicating that the Celebrate software has parsed it in multiple locations.
If you could start reading. In searching 3B in the document, we see here multiple sources. You could do a search with the number 3B. So we see here at 4:43 p.m. on January 24th, a search for the 3V menu, correct?
Yes.
If we could scroll down a little. And again, those are all at the same time, so they indicate one search for the menu?
Yes, and the tools parsed it in multiple categories.
And if we could go back. Was there also a search for an Apple Maps for 3V?
Yes.
And what time was that?
I'm sorry, there's a glare.
If we could go to 4:13 p.m. And here in Apple Maps, do we see 3V restaurant at 4:13 p.m.?
Yes.
And when you're using a map feature to look up a location, such as Apple Maps, what type of information do you learn when you plug in a location or an address into Apple Maps?
A route preview.
And does that route preview give you a length of time it would take to travel to that location?
Depending on what you indicate as your originating location, yes.
And so if you plug in 3V restaurant to Apple Maps and it maps out a route to get there, does it tell you from your location to 3V how long it would take to get there?
Based on traffic conditions, yes.
Because that changes constantly, correct?
Yes.
So if I open up my Apple Maps and I put in 3V right now from here, at this time, the time it takes to get there might be different than, say, at 6 o'clock tonight.
Yes.
And so if we can go to 4:47 p.m. And here at 4:47 p.m., again, we're seeing the search for Kids Miralax, correct?
Yes.
Is there also a visit to a CVS website? here at 447:04.
Yes, it's categorized in multiple categories within the tool, but it parsed an artifact at that time.
If you could scroll down a little, please, to the phone call, the next phone call, right here. This outgoing phone call at 4:48:21 to 781-585-6581. Did you learn that that was a phone call to the CVS at 189 Summer Street in Kingston?
Yes.
And so that would be an outgoing phone call from the defendant's phone to CVS.
Yes.
Can we go to 4:53 p.m., please?
Why even place that
And then
call,
there's a
counselor?
message. It says message 80, outgoing.
Why even place that call? If at the end of the day, it doesn't even matter if the stuff is there and this is all premeditated, why even place the call? Why not just send him? It didn't matter if they had it or not.
From the defendant's phone at 4:53:09 from Lindsay to Patrick Clancy, correct?
Yes.
And it says, any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day, correct?
That's the content of the message.
Is there a response in message 82 from Patrick to Lindsay?
Yes, there is.
And what is the answer?
Yeah.
And then is there a response from Lindsay to Patrick at message 84?
Yes.
And what is that?
Okie dokie.
And then message 86, again from Lindsay to Patrick, does she send him another message?
She does.
And what does that say?
Check the menu when you can.
And then if you could scroll down to the next message. Is that message 90 from Patrick to Lindsay asking if Callan just got up?
It is.
And then message number 92, is that from Patrick to Lindsay saying also, what are you getting?
Yes.
And then 94 at 5:06 p.m., is that from Lindsay to Patrick, stating, but it was just a short nap in message 96.
Yes.
And then message 97 at 5:06 is 3D menu searched.
Yes.
And that source says Safari. Is that a Safari web search for the 3D menu?
Safari is the default web browser on an iOS device, and iOS stands for iPhone operating system.
So that's a basic search on your iPhone for the 3D menu.
Utilizing the Safari web application, correct.
And then number 98, is that another search for Pedialyte?
Correct.
Excuse me. Now, both the search for 3D menu and the search for Pedialyte are at 5:06:45. How does that happen, that there are two searches for two different things at the same time?
Can you repeat the question?
So you have in message 97, you have on January 24th, 2023 at 5:06:45, a search for 3D menu. Then the same date at the same time, a search for Pedialyte.
And what's the question?
How does it happen that you have two searches at the same time?
I would only be able to make an inference from here without having the forensic tool available to me.
And what would the inference be?
That there was more than one tab open.
Okay, so on your phone or a computer, when you're doing web searches, you can have multiple pages open, correct?
Yes.
And you can just click on whatever page you want to open, you can click on and that will open up.
Correct. You can select which tab you want within the Safari application.
Tabs, right? Okay. So how many tabs can you have open at any one time?
I'm not sure the number, but I've seen iOS devices capable of having more than 30 or 40 tabs open at a time.
So it wouldn't be uncommon or unusual to have at least two open to two different web searches.
No.
Okay. If we could scroll down a little, please. And then we have in 106 and 105, both messages. First 105, we have a web history at 5:06:47.
I was thinking the exact same thing, Janine. Wait, What happened to the phone editing stuff? Where'd she go with that? She must be saving it for this last bomb of a witness that's next. Bob said 3 witnesses. We've seen 2. So, or we're seeing the second.
The menu at 3V Restaurant, again, the Source Safari. And then we have cookies at 50648.3vrestaurant.com. Can you tell us what the difference between those two are?
They're both from different databases. They're both associated with web browsing. Web history is from the history component of the Safari application. Cookies are installed through web browsing. Through legislation, when you visit a website for the first time, you'll typically be prompted, do you want to allow the website to download cookies onto your device? Cookies downloaded to your device serve a multitude of reasons. One might be that it allows the website of the company to be able to track your activity while on their website, which helps them for marketing and business purposes. Another component of cookies would be to enhance the web browsing experience for a website you go to on a regular basis. It would increase the load time. So it is an artifact that is indicative of web browsing.
And so message 108, again, we have at 50649, we have a message from Patrick to Lindsay saying, oh, okay, is that correct?
Yes.
And then message 112, we have a message from Lindsay to Patrick where she says Mediterranean Powerball, correct?
Yes.
And that was at 5:07 p.m. We have a message 115 from Patrick to Lindsay at 5:08 p.m. Okay, I'll do scallop and pork belly risotto. Is that right?
Yes.
All right. And then if we could go to 5:10 p.m., the phone call right there. Oh, go back to it. And so we have 2 phone calls here. One at 5:09 p.m. and one at 5:10 p.m. The first to 508-747-4950, and the other to 508-927-4046. The first one is for 11 seconds, correct?
That's the duration, yes.
And that's noted here above source.
Yes.
And then the second is 47 seconds, is that correct?
Correct.
Did you look into these 2 phone calls?
I don't recall.
Okay. Do you recall the 508-927-4046 being the number for the 3V restaurant?
Yes.
And if we could scroll down a little bit. Are there further searches at 5:13 p.m.?
Yes, this witness makes very annoying breathing, dry mouth, nose whistling sounds. All the things. All the things.
Starting at number 128 for Pedialax.
That's correct.
And again, we're seeing that same thing with
I'm speeding this up
the
to
same
1.25.
time, but
Can't take it.
multiple
Done.
different categories that one search is located in, correct?
Correct. Single artifact, multiple categories that the tool parsed it as.
Can we go to 5:33 p.m., please? Oh, I'm sorry. Stop there. Thank you. 146, message 146, a message from Lindsay to Patrick at 5:15 p.m., which states Pedialex liquid stool softener, correct?
Yes.
Right. And then at 147, we have 5:33:51 p.m. Is that a phone call from Patrick's phone to Lindsay's phone?
Yes.
And that has zeros in it for duration. Does that indicate the call wasn't answered?
It would be an inference.
And then going down to 150, we have an outgoing call from the defendant's phone to Patrick Clancy for 14 seconds at 5:34 p.m., correct?
Yes.
That means the call lasted approximately 14 seconds.
Correct.
5:34.
And then the last item there, item 152, that is an incoming call to the defendant's phone from Patrick Clancy, correct?
Yes.
And again, we have zeros here indicating that the call wasn't answered, correct?
It's an inference, yes.
If I could have these reports that I just went over submitted on this disc as the next exhibit.
That may be admitted.
236. Did you also looking through the defendant's phone, access the information on the calendar portion of the phone.
I did.
And the calendar portion of the phone, does that have different types of data, both populated by the phone itself in Apple and then items populated by the user?
Yes.
Could you give us an example of something that would be populated by Apple and not the user?
A national holiday such as Christmas Day would be populated by the operating system through the application of calendar.
And then if I'm using my phone and I'm putting in appointments or parties or things I'm going to, that would be something that the user is putting into the calendar?
Correct.
And did you do a report of all the calendar activity for Lindsay Clancy's phone from August 4th, 2022 to January 31st, 2023?
I did.
I could have this marked as an exhibit.
All right, that may be admitted. Ms. Sprague, is this a good time to take the morning break?
I just have one more exhibit to put in and then I would be done.
That's fine.
Did you, I'm sorry.
All right, thank you.
Did you also do a report on all the text messages between the defendant's phone and an individual that had been labeled mommy?
Yes,
And was that for the month of January 2023?
I did.
We moved to have these exhibit as the next exhibit.
All right, that may be admitted.
I have nothing further.
All right, so why don't we take the morning recess at this time? All right, so members of the jury,
Who is this last witness? Is it Ian Whiffen? I thought he was on vacation. Let me see what my man's saying on the X machine. All right. So he did give us a little bit of a timeline, which is very, very helpful. So we've got 5:13 Pedialac search, 5:33 call from Patrick to Lindsay, inference the call wasn't answered. 5:34 14-second call from Patrick Clancy to Lindsay Clancy. And then Bob writes call returned ? Well, not if it was from Patrick to Lindsay. Commonwealth sure buzzed through what I thought was some of its most critical evidence, at least in their estimation it was. I mean, and then he goes on to say, I mean, the 14-second call is a big deal according to the Commonwealth, right? Yeah, babe, exactly. I feel the same way. I mean, that's they think it's the everything. They think it's the everything. It's crazy. It's crazy. Well, let's see what you guys are saying. So Brian asks, why bring the calendar up and then say nothing about it when it was in and what was in it? This is their laying foundation guide, just getting the stuff in. Whoever this last person is like the one that's going to put the last of these pieces together. So is Bob in the chat? If you're seeing Defense Diaries and it doesn't say Allie in front of it, then yeah, that's Bob. Because if I type, I typically write, is Bob in the chat? Where are you at, man? Let me tell him. We want to chat wants to hear from you. Let's see. Chat wants to hear from you. All right. I told him, come comment in our chat. Not that Susan says 3 words to describe this trial: horror, boredom, and confusion. Yep. The young Cryford says, and thanks for your continued support. I often look up directions to place I have been to all the time. Lana B says, real talk, as a juror, if you're disgusted by the prosecutor, can you get kicked off the jury for staring them down? My face shows everything. I wouldn't be able to hide it. I mean, that's an interesting question, because if I had a juror staring down the defendant with disgust on their face, well, that'd be a different story, right? Because I'd be like, they've already made up their mind. Look at them staring at him with disgust, or they're afraid of him, or they're this. I mean, I can imagine the prosecution could make a similar argument, but I don't think so. Because if they're staring at one of the lawyers doing that, it's like, well, whatever you're doing is god awful. But I would do the same. If I caught a juror staring me down in disgust, I'd be like, this person hates me, and it's going to be held against the defendant. But I mean, I don't think so, but maybe. Good, very good question, Lana B. Majin Kazu. Bob is great, but Allie's righteous fury gets me hyped for justice like I'm at a courtroom metal concert. Thank you for the excellent coverage. Oh, thank you. Thank you. Ooh. Mama Deb raises an excellent point. Allie, can you create a poll? I was just wondering how many people think, like me, defense does not need to put on a case and end this madness. I could put up a poll. I think. Actually, I can't. Because I'm pretty sure I have to do the poll in YouTube, of which I've been kicked out as defense diaries, and I don't know. Can't get back in unless Bob, because of their two-step authentication, unless Bob's sitting there to press a button. So, but I'm gonna have to get back in actually, because we're gonna need a poll at the end of their case, which it's about to end. Thank you for your generosity. Resting bitch Britface says, if I could just have Allie's lady get a fucking clue for a ringtone. Yeah, that's a good one. Thank you. Alana Burns became a member. Well, welcome. Thank you. Midwife Shells is back. Sorry, I know I'm going backwards, but even if she had searched it in August, red proof she didn't, that still doesn't help the Commonwealth. I 100% agree. That would prove she had suicidal ideation for even longer, and that doesn't help them. I 100% agree. I mean, it seems like they're trying to say, oh, Bob was in chat. I was off stream. I was trying to find a snack. I'll come back in. So Bob will come back into chat. So one have the and Bob, I think he's been getting some Venmos that he's gonna go on. Did Bob say anything good while he was in the chat? I mean, I'm sure he did, but I mean, like, informative speaking. It doesn't help them. They're just Grandma Kate makes says, could the way they're presenting the case and misleading the jury be prosecutorial misconduct? I say abso-fucking-lutely, hands down, without a doubt. They're misleading the jury. That is prosecutorial misconduct. So that is a form of prosecutorial misconduct, intentionally misleading the jury. It should be. It should be. Midwife Shells also says Red is eviscerating the ADA, which was during that whole, she wasn't even home for the search thing. The virtual juror says Reddington said August 23rd, 2022. And that was to my question, like, wait a minute, is she saying he had the wrong date? And again, the appointment was at 10. probably, and she was seen at 10:15. And he said there was something in the records that says he got there around 10ish. But I knew what you were asking, and I appreciate that. CU Buff's mom says, didn't Patrick say he didn't access her Facebook? He did. He said he didn't, like, that wasn't like a thing that he did, is go on his wife's Facebook. But that doesn't mean that your wife's not the one logged into Facebook when you happen upon Facebook searching for something else, you know? So I don't think it's, you know, that big of an issue. But no, you're absolutely correct, CU Buffs. That was what Patrick said. Midwife Shells comes back. Thanks for your continued generosity. I want them to dismiss the jury and Red look at the judge and say, are you kidding me with this, Your Honor? Yeah. I'm with you. Chicken Shite says, the state is entitled to put on the case they want, needs an upgrade. Judge needs to be able to shut down these horrible cases, shut these horrible cases down easier, in my opinion. As a lawyer, I wholeheartedly agree. The gatekeeping function needs to be more, they have the discretion, you know, but they give so much leeway. It's crazy because they could say, as the gatekeeper, there's no basis. The inferences to make what you're saying true are not reasonable inferences from the evidence. Stay the fuck out. But there needs to be something a little with more teeth, something a little more, because, you know, every lawyer, every defense attorney known to man has tried it. There's no basis for this. They're like, they'll stretch and they'll contort and they'll figure a way to say, I mean, it could be a reasonable inference. But I wholeheartedly agree, Chicken Shite, and thank you. Love you guys sharing the jewel emojis. Appreciate it. You appreciate it. Chicken Shite also said Commonwealth comes up with these theories, then puts up 20 witnesses to prove their theory wrong every time. I feel like I'm in the Twilight Zone. Yeah. Yeah. Sorry, that was a client. Yeah, I feel like I'm in the Twilight Zone too. Like these people have no social like awareness. They've got no common sense. They don't know anything about. It's like, do they even have parents? Do they even know what parents are? I mean, you had to have parents at some point, right? Got to turn my. I thought I had myself on focus. Where are we? All right. Love the drool support. Greatly appreciate it. The Devil's Lettuce member for 1 month. Imagine if Lindsay Clancy and parents didn't have the money for Karen Reed. Oh no, for Kevin Reddington. Jesus. I'm like, wait, I'm missing something here. What am I saying? That's not what Devil's Lettuce is saying. Aw, and Devil's Lettuce, your dog is so cute. It's got the same coloring as my little guy. Or my big guy. My big, sweet, lovable guy. Oh my gosh, you guys, I can't stand it. Hide myself. Yeah, imagine if they didn't have the money for Kevin Reddington. We'd be completely and totally, she'd be completely and totally screwed. Screwed. Kate Cat says, "Go to God, baby." That's the quote from the complaint that it says Lindsay said while she was doing this to the kids. And not hiding the bodies. So you're doubling down the scenario. To me, suggestions suggest an inability to appreciate wrongfulness. Can you explain this, please? I mean, just because you believe you're sending them to God, which in theory is like a good place, doesn't mean you don't know what's wrong to send someone to God early. But your point is taken. Like that, there is a way that maybe, in conjunction with other factors, such as not hiding the bodies, um, that would suggest an inability to appreciate wrongfulness. It's just a really, really big stretch. Like if they've got their whole thing of, you sent Patrick away, because you knew it was wrong. Definitely knew it was illegal, but you make a good point that those types of things, like not hiding the bodies, is something that suggests, well, you don't think it's wrong. It's like the counter of, you're trying to hide your crime, you're trying to cover up your crime, you're trying to come up with, clean things up so you don't get caught. It's the reverse of consciousness of guilt evidence. But, then the argument is, well, she never thought she was going to be able to hide the bodies. I don't know. I mean, you make a point, but it doesn't seem to me, at least what we've seen thus far, that they're relying on any inability to appreciate the wrongfulness. Amanda Vett says, striking resemblance between the author, Charlotte Perkins' yellow wallpaper, and Lindsay Clancy's story, just for any literary nerds out there. It sounds like it's not a stretch if you know the medical history, or know a lot about these conditions and what can happen. Nikki Lee, welcome. Family hug. Amy Bergman says, I'm so excited for Red to put on his case and defend Lindsay Clancy. I'm so excited for Red to put on. Oh shit, I think it duplicated. Let's fucking go. Got some jewels. Always love the jewels. I mean, Danielle says, I want to know how her thyroid was crushed. Yeah. I think if you go head first, right? And wouldn't that be the only way? Oh, wait, her thyroid. Oh, Lord. Don't listen to me. Can we rewind and delete that? I don't know what I was thinking. I'd like to know too, but it probably how the body like folded when it hit the ground, which also could have been more indicative of a head first and I don't know. I shouldn't even have tried. But yes, it's something that we will all be looking forward to hearing. Meemaw, cat, bracing myself for today. Yes, everybody needs to. I read Trial Addicts earlier. Thank you. True Crime Addict said there's a new 14-day course of med that helps with postpartum depression. Why not offer a script for that to every woman who gives birth? No stigma to ask for it. I mean, or at least have it be something like the script is available if you need it, like more upfront. I don't know about prescribing something people don't need just in case they need it, but your point is well taken. It gets offered to everybody. You know what? Maybe that is. What's a 14-day course of a med going to do anyway? So I think that's not a bad idea. True Crime Addicted. Just prescribe it, and then someone can fill it if they need it. Because what's a 14-day script? It's not like someone's going to start abusing, that medication, giving it to other people. So I think that's actually a good idea. I retract my initial statement. Bay Harbor Beauty Unfiltered became a member. That actually reminds me. So I have been using the Bay Harbor products, and I think it's been like a week and a half. And honestly, I am loving it. I'm loving it. I'll tell you guys more about it after I get some more under my belt, but it's really, really amazing. Like my face has been feeling so like softer and healthier and looking better and brighter. Um, so I'll talk to you guys about it on a longer break, but they got good stuff. We got good stuff. I'll tell you about all the things I'm using. Hello. Just a thought, but just a thought, but am I the only one that thinks the cops? Oh, I read this earlier. Thank you. Hello. Right. And I read this one earlier too, but it's worth rereading. Jadzia. She rang to CVS to find one with Cora's meds in stock, then picked a restaurant closest. Nothing nefarious in that. Yeah, it's again, send her to one that doesn't have it would take him longer, give her more time. Not even calling because it doesn't matter if they have it or not. All the things. And hope. Yeah, that's kind of how we started this morning. It's like she was worried enough to check the distance so she could, mentally prepare herself for how long she'd be alone. In hindsight, it's like, just say the words to him. Like, I'm afraid to be left alone. And then he'd say, all right, I'll take the kids with me, or let's all go together, or we can order, like DoorDash, But yeah, any way to have a different ending. And Megan, maybe not. I did read your comment earlier. Thanks so much for sharing. It's a horrible story. My daughter-in-law called 2 nights ago having a breakdown. She's 4 months postpartum. Told her doctor she feels like driving her car into a wall, and they said that's normal. And I think that's like the problem here, because normal is not the right word, right? That's that's a symptom of postpartum depression. A lot of women suffer through this. Not it's normal. A lot of people suffer through this and treat it with the urgency it deserves for the person experiencing it. Just because it happens all the time doesn't change how horrible it is for the person going through it. And that's where I think there's been like a part of the whole. Am I live in the courtroom? Yeah. Detachment with the medical providers, with the mental health system. It's like, no, it's not fucking normal. It's not fucking normal. It unfortunately happens. You're not alone. A lot of people suffer through this. It's so serious, but it's not, you're not crazy. You've just, your mind has been altered by, whatever, the condition of your hormones, your body. I don't know. And Miss Rattle made that great point earlier. I think a thought that everybody has. Lindsay Clancy could have picked that restaurant because round trip, when including CVS, it made the trip a lot shorter. So I think that gets us everything from this morning. Let me go back down to see. We've got Stacy Knott Esquire. Welcome. Family hug. Got some more jewels. Love the jewels. LHR says, my therapist told me those meds are in research and the plan is to offer to every pregnant mama. The goal is to prevent PPD. All right. So that goes to the other person's comment that I said, you know what? Yeah, actually, dude, let's do it. That's not a bad idea. So thank you. IHR or LHR? Probably IHR. Or 1 hour. No, it's not a 1. Okay, sorry. Pantofel. I can't read. Doesn't the Commonwealth arguing Lindsay Clancy wasn't taking around taking enough of her meds support her PPD, PPA, or bipolar, and undertreated and deteriorating, like leading to PPS and inability to appreciate wrongfulness of her actions. I mean, there could be a sense where there's no inability to appreciate the wrongfulness of that there is an inability to appreciate the wrongfulness of her actions, as the earlier comment I read pointed out as well. I just didn't think that that was the path that the defense was going, especially because of the pleading. But I haven't heard anything, so but we'll see, I guess. All right, looks like things are moving. Some more jewels. Love the jewels. And yes, Jenny Lulu, PC logged into his Facebook and viewed her Facebook Wait, PC logged into his Facebook and viewed her profile. Is that accurate? I thought it was.
All right. This court is back in session. You may be seated.
Guess
All
we
right,
need
Counsel, ready for the jury?
Yeah, thank you.
That's clearly some lawyer he's consulting with, if that's not his son. It could be his digital expert.
All right. Thursday.
All right, yeah, that's what I just realized. Thanks to virtual jury.
The court's now in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
All right, Mr. Reddington?
Yes, Your Honor, thank you. Morning.
Morning, sir.
So you are part of the prosecution team that handles the downloads of computers and cell phones and things like that, right?
Specifically mobile devices, sir, not computers.
Mobile devices, okay. And the other gentleman that testified, Pavao, is that his name?
Pavao, sir.
Pavao. And he did the laptops that were found in the office, in the home, right?
Correct. He has those certifications.
Okay. Now, the district attorney had asked you some questions about different searches that you had done on Celebrate and on Axiom. All your searches dealt with Lindsay's cell phone, right?
To clarify, sir, I did no searches on Axiom.
Okay. You did searches on Celebrate.
This is the only forensic tool I use, correct?
All right. And basically, I'm just trying to get a handle on that you and your other brother or sister officers would examine, for example, the computers that were found in Patrick's office in the house, right? You didn't, but the other people did, right?
That's correct.
And then you got the computer, strike that, you got the cell phone that was Lindsay's cell phone, right?
Yes, sir.
And you then did, what's called an advanced logical of Lindsay's phone. Is that right?
That's correct.
And what is an advanced logical? What does that mean?
It's an extraction that utilizes the iTunes backup of an iOS device, and it acquires most of the user-facing content, meaning calls, texts, images,
Okay.
browser history.
So you lost me on user-facing. What does that mean?
What the user sees when they're using the phone.
Okay, so like if you pick up a phone and you open it up, then you're interfacing with the phone and you're looking at different things, such as photographs, emails, text, things like that.
Yes, sir.
Okay. In addition to Trooper now Sergeant Pavao, and yourself, there also was another trooper that you were working with, a guy by the name of Rabbit, like Roger Rabbit, right?
Yes, Joseph Rabbit was assigned to the unit at the time.
And he also conducted a search, but he did what's called a full file system extraction, right?
I don't recall.
Okay, what is a full file system extraction as opposed to advanced logical extraction?
A full file system extraction would acquire the databases and information that you cannot see as a user on a device.
I see. So your extraction was done on January 30th, is that correct?
Yes, sir.
And Rabbit's extraction was done on January 27th, right?
I'm not aware of Trooper Rabbit's extraction.
Did you ever collaborate with him as investigator investigating Lindsay Clancy on this case and talk about what you located, what he located?
I had no discussion with him about the phone extraction.
All right. Is he still working for the state police?
He is.
Would you agree with me that the full file extraction actually gets more information than the advanced logical? In other words, Rabbit's extraction would have got more information than you got on your advanced logical.
That's correct.
So one of the things the district attorney had asked you about was in reference to Exhibit 237. And that would be the Celebrate report. Is that correct? Basically, the caption for the extraction on the Celebrate report.
This is a supplemental report
Okay.
that I completed from the physical analyzer software.
Okay. And would that be Celebrate?
Yes.
So that's why I asked. Looking at Exhibit 237, the second page, that on the very top that I'm looking at here, can you tell me on the right, what is it depicting on the right?
It's
a little box.
Brightness instead of the.
Yeah, I know that. You see the little box? Oh, well, you know what I'm going to do? I'm just going to approach you. This here is the exhibit.
I'm just going to use it.
The attorney asked you to look at 237, right?
Yes, sir.
Okay. And it's a Celebrate report, right?
It's a supplemental report, yes.
And that would be the calendar search, right?
The calendar supplemental report, correct.
Okay. So that means that if Lindsay had appointments anywhere, it would have been presumably, if she put it in the phone, in her calendar, right?
Yes.
Okay. So when you looked at your investigation, directing
That's
your
probably
attention
right.
to the start time, what date are we talking about here?
The start time is August 14th, 2022 at midnight. End time would be August 14th, 2022, 11:59 p.m.
Okay. So if you look down to the next one, it says, what date?
August 23rd, 2022, 10 a.m.
Okay. And did she make an entry
She
on
did.
her computer on that date and time?
She did, sir.
And can you tell me what the entry was?
The subject is 10 a.m. Callan, Kingston vaccine.
So Callan would be the son. She had it in her phone that he had an appointment to get a vaccine at 10 p.m.?
The time is 10 a.m.
10 a.m., okay. And the next one, what is the next one?
Would you like to know the subject, sir, or the date?
Yeah, sure. Just what the date is and then what the subject is.
Okay. The start time is August 23rd, 2022, 5 p.m. The subject of the entry is 9:45 Kingston, Dawson, ear check.
And that would be indicative of an appointment that she had at the pediatrician's office for Dawson's ear check at 9:45 in the morning. Is that correct?
Could be an inference, I'm not sure.
9:45 in the morning. 9:45 in the morning. There's something really wrong with this prosecution. It's like, come the fuck on.
Now, looking at Exhibit 235, you can tell me, what is this document?
I recognize it as a screen capture from an Axiom phone extraction.
All right. And you did indicate you were Axiom qualified, right?
I am not, sir. I'm familiar with the program as a result of my training at Great Key. Magna Forensics owns Great Key Technology, and in the training course for Great Key, process extractions using Axiom, but I'm not certified in the software of Axiom.
But you can interpret it. You understand what that shows you. It's just a listing of different activities on the phone, right?
I'm aware of what the screenshot depicts, yes.
All right. Can you tell me see the highlighted one, can you tell us what that is, the date, the time, and what it's referencing? Do you need a magnifying glass?
Reference is a website, sir.
And what's the website?
Mail.google.com.
That mail, like M-A-I-L, right?
Yes, sir.
Okay. Does it indicate whose mail it is? Does it show it on the right-hand side of the box?
I can't definitively determine whose mailbox it is.
Okay.
Trooper, I'm going to ask you, make sure you keep your voice up, okay?
Yes, Your Honor.
The next page. It's pretty much the same thing in the same day. Can you tell us on that page who signed in under what email?
Oh, please do.
The artifact is indicating that there's a title with an email.
What's the name?
I'm sorry. patrickclancy@gmail.com.
So
Oh,
that's
Patrick
gonna say
Clancy.
That would be patrickclancy@gmail.com. That's his email that's signed in on Lindsay's Facebook. Did I say?
I can't confirm that.
Okay.
Wow. Wow.
And when you were going through her phone, is it fair to say that, I mean, there wasn't much in her life that wasn't exposed to the state police and the DA's office and the investigators? I mean, your report initially was 180,000 pages of PDF, right?
It was a very large download, sir.
Does 180,000 sound about right?
It does.
So 180,000 pages on a PDF, you do a number of extractions, and then you get into the one that you were testifying about. The district attorney indicated, or you stated that it was 768 pages of text messages that she had, along with photographs perhaps.
That was a timeline search. The number of items in that report are indicative only of the time frame in which I was utilizing within the software.
Okay. So when you went through her phone, did you come across on a Celebrate report searching for where is the carotid artery?
I don't recall.
Did you come across, might be easier this way. This is a Celebrate report on Lindsay's phone, right? Now, I understand that you might not have been standing next to another cop going through the records and documents on her phone, but on this, you're able to recognize that as being the Celebrate report, right?
It is a Celebrate report, sir.
And it's a Celebrate report for her phone. You can tell by the numbers, right? Maybe this would help a little bit. You see this here where it talks about source file and it's got a number, quadruple 08110-000925E and all the rest of them. That would be her phone, right?
I don't have that number memorized.
Of course not, but it would be in your report?
Yes, sir.
Okay.
It would depend on the supplemental report that you have, sir, whether or not that character was displayed.
I don't know whether to look at it. You can tell me if that's, because this is, we agree, it's Lindsay's cell phone. Celebrate extraction report.
This item you have here, sir?
No, I'm sorry, the exhibit.
This is the calendar supplemental report, yes.
So Lindsay, so what's the number? You must have a number that would connect to her phone, like an address, like your home address, but in fact it would be a number, right?
It's a device identifier. It is not presented in this supplemental report.
Okay, where would the device identifier be presented?
It'd be presented in the front page of the initial extraction report.
And that's the 780,000, or whatever it is, pages, right? You don't have that here. Certainly 180,000 pages. You don't have that here, right?
No, sir.
Excuse me, Your Honor.
What a fucking joke.
Mr.
This is what the defense has to do to just disprove something that the Commonwealth knows damn well wasn't true to begin with.
Did you bring your report today with you? Just the report, not all the exhibits?
No, sir.
So you would agree with me, sir, that one of the concerns as an investigator that you had is things such as looking for buzzwords like suicide, right?
I'm not sure I understand the question.
When you're looking on the target's phone, and out of this whole courtroom, the target would be Lindsay Clancy, right?
Yes, sir.
All right. And you had access to her phone, right?
Yes, sir.
And you all went into it with a search warrant, right?
Yes, sir.
And you were looking for different topics such as suicide, drugs, killing kids, I imagine, to investigate, right? You had buzzwords.
Yes, sir.
And did you come across, for example, a search that indicates carotid artery?
I don't recall.
Did you come across a search on Safari, how to slit your throat to die?
I don't recall.
What the fuck were you
Did you
looking
come
for?
across a search, can you turn airbags off on Kia Sorento?
I don't recall.
Did you know that she had a Kia Sorento?
I did not.
If I approach you with this Celebrate report, sir, does that give you the numbers for what I just went through with these searches?
The universal device identifier is a match.
It is
Thank
a-
you.
Okay.
God's
Between
sake.
this document in my hand and the ones that you're holding.
So would you agree, what's the first search on the first box?
The value associated with the source file is carotid artery.
And the next box?
How to slit your throat to die.
And the next box?
Can you turn airbags off on Kia Sorento?
These all came from Lindsay's phone, right?
I can't confirm that.
Well, it's a pretty good inference, right?
Yes, sir.
Okay. Run right off of these.
If we could just see them at sidebar.
Scumbag. Scumbags. We're live. What a fucking joke. What a fucking joke. So Patrick's email was accessed by Patrick on a computer that was still logged in to the Facebook of Lindsay. Come on, people. And I don't give a shit even if she did make that search. But what makes it even more ridiculous is she wasn't home. It wasn't her computer. It wasn't her search. And the search didn't matter in the fucking first place. Grammy B says, am I wrong for trusting Reddington completely to make this right? No, he's doing it. Your trust is well placed. And the ADA wants to fight every piece of evidence. You're a liar. I think the judge should be over there saying, you're a fucking liar. I've been keeping a little tally of all the lies you've told this jury, of all the misleading statements you've told this jury, of all the twisting and contorting of the evidence and the facts to this jury, not to mention the traumatizing of the jury. Yes, what Brian says, they just want a win at all costs. And this is why just being a defense attorney is so frustrating. It's like, the world is seeing what we see every fucking day. Almost. In almost every major case that I've handled, fuckery. Bullshit. Manipulation. Facts that don't say what they say, but they say them like they sure as fuck do. And it's getting fucking old. It's getting fucking old. Something needs to be done. Lizzie says, if you want an infant seat in the front, you have to turn airbags off. Yeah, but who would put their infant seat in the front? I'm confused. I mean, I think she's looking to turn off the airbags. So if she wants to kill herself in her vehicle, the airbags aren't there to protect her. Right? Or am I misunderstanding your question? Or your comment, I guess, is a better description of what you just did. Amy Slates became a member. Welcome. Thank you. Some more jewels. Always love that. Kelly Steffi says Bobsey twins should just say 227 didn't happen, for fuck's sake. I mean, I didn't know. Was that what they were like getting at? It was like, now you're just throwing in facts like to like on the DL, be like, hey, remember that other case? The prosecution was right, because I didn't know what the hell they had any relevance to do in this case. It was like, okay, yeah, we know. The other tab was open. So basically, you can't trust the time on any of your windows because there might have been another fucking tab open. Real tea with Krista Marie. Look at you, Krista. Okay. I see you. All this shit is just noise. He is using tech word that make it sound much more complicated and being very sus like a dick. What the fuck? I need to scream. Yes, I know. I imagine. Is that what you actually look like? Real tea with Krista Marie? Quite stunning. Quite stunning. Oh. All right. Mama Loca said, and thanks for your support, you guys, Kelly, Krista Marie, all of you. Mama Loca said, this is probably weird, but, and I feel like this is the only answer because I was left wondering before. I think the entire conversation about how Lindsay modified the photo so they weren't love photos anymore, which I didn't even realize that's what happened. I must have been like, was purposeful, insinuating she knew the kids wouldn't be alive soon. Weird thought. I know. No, if that's what it was, then it was definitely like she unloved the photos because she unloved the kids. She was going to kill the kids.
Thank you. And just, thanks. And if I can, just for continuity, sir, looking at what has been marked as Exhibit R, S, and T for identification, not an exhibit yet, the jury would have, but nevertheless, we can question you about it. You do agree with me that the phone identifier numbers are listed here, and they're pretty much the same on these three exhibits, right?
Yes, sir.
So here's what happened. The Commonwealth, who knows fucking damn well this is from her phone, is saying that he hasn't been able to prove, and she wanted to do it on a sidebar so she didn't look like a total idiot, asshole, fuck face. Okay? Fuck face. He hasn't proved it's her phone. The witness said, I can't say it's really her phone. This isn't a game. This isn't a chess move on your stupid fucking board. I will flick your chessboard and fucking scatter it all. You know it's it. Why are you trying to fight it getting in? Because it says the truth. So, all right, make him come back and put it all together again. When you know it's the fucking truth. Gosh.
And that would be Lindsay Clancy's phone, right?
I can't confirm that.
Get your report out. Make the Commonwealth give him his report.
Yes, sir.
So I've just handed you Exhibit 237,
Now I
sir. Can you
can't
tell
turn
me
it in.
what that exhibit is? The
Yes.
district attorney questioned you about it.
It's a supplemental report that I compiled from the Celebrate software on the calendar application.
God.
Do you have access to what was referred to as the mummy text messages?
Not with this document, sir.
So that document is the calendar that we had already gone through as far as seeing the doctor, 9:45 and 10 o'clock appointments, right?
That's correct.
All right. Is the
Exhibit 238.
No, he didn't get to put in the evidence. Not with this witness. He'll put it in with his. He did enough. It's just ridiculous.
Exhibit 238, sir.
Exactly.
On the exhibit, sir,
Yeah,
this
but
would be captioned the mummy text message thread between.
It makes no difference, but it just goes to the depravity of these prosecutors, to the just slimy disgustingness of these prosecutors manipulating every fact.
Is that 36?
For January of 2023, sir, yes.
Okay, so this search was limited by the police to January of 2023 for the texts between Lindsay and her mother, right?
Correct, sir. It's a filtered supplemental report from Celebrate.
Filtered supplemental report, okay. So who would be, when the jury's looking at these in the jury room, who would be the blue texter? Would it be Lindsay or her mother?
You could just look at the participant delivered status sent from Lindsay owner to mummy. So the green would be
Mommy.
from the owner of the phone to the recipient, mommy.
Okay,
mommy.
so green would be Lindsay, blue would be the mother.
That's correct.
All right. Now, let me give you Exhibit 238, and just for a representative example, I mean, looking through, will you look?
I mean, I hear you, Nikki, and nobody jump all over her, but that's not what happened. She didn't just kill her daughter. She didn't kill her daughter in the car. So you've got to take things in, you have to look at things in the overall picture while she's Googling other ways to kill herself. So, but, appreciate you.
Look at September 28th at 6:18 in the
heart.
morning.
Sir, can you repeat that date?
Basically what I
Yeah,
just
sure.
did.
September
Bless her heart.
28th. Oh, you didn't do, that's right, you didn't do September, you only did January, right?
Sir, this exhibit is just for January of 2023.
Okay, I apologize. Let's jump to January then. Now, let's say January 3rd, 8:35 in the morning. Do you have that?
One moment, sir.
Sure.
Yes, sir.
And what did Lindsay say to her mother on January 3rd at 8:35 in the morning?
At 59 seconds, sir.
Yeah.
I'm all right, period. Anxious about meeting with the whole psychiatry team.
How about the next message that she sent at January 3rd at 8:37 in the morning?
In 31 seconds.
Sure.
I'm just worried they won't send me home soon.
Now, do you know, as a police officer working on this case, what she meant, send me home? Do you know where she was on January 3rd?
It would be an inference only, sir.
That's all right. You can infer.
I believe she was in a medical facility.
McLean Hospital.
I recall that hospital being mentioned.
And then on January 8th, sir, at 10:44 in the morning, was there a text from her mother to Lindsay, if you know? 10:44. Where the mother asked, did you sleep good?
1 second, sir. It's cut off by the clip here.
That's true.
10:44 and 30 seconds a.m.
Real good point. I love when the chat comes up with things. The whole reason you don't put your children in the front seat is because they don't weigh enough to trigger the airbags. So, and we'll keep going.
Yeah.
From mommy to Lindsay. Great. That will be fun. Sleep good last night? ?
And did she respond? She meaning Lindsay?
She did.
What'd she say?
I actually did.
And this was on January 8th, sir?
That's correct.
January 10th, could you pull that up, please, at 9:48 in the morning?
It's a stupid thing to keep focusing on, but I did just Google it. And most modern passenger seats require between 65 to 100 pounds, approximately, of weight to turn the front passenger airbag on. If the occupant weighs less than roughly 65 pounds, the size of a small child or infant, the occupational classification system automatically deactivates the airbag to prevent severe injuries from developing. What did I do here?
Could you pull that up, please, on Lindsay?
Going back.
She did.
What'd she say?
I actually did.
And this was on January 8th, sir?
That's correct.
January
Takes a
10th, could you pull
village.
that up, please, at 9:48 in the morning?
Thanks, chat.
I apologize, sir. Can you repeat the time on the
Sure.
10th?
9:48 in the morning, beginning with mother asking questions of Lindsay. Still sleeping good, ?
Another adorable picture. The stay-at-home juror. I mean, yeah, it's literally everything we all do. You can take it.
I have a message at 9:48 and 15 seconds.
This case really just proves, I mean, really, that they could take any normal set of circumstances in any of our lives and basically put us into some sort of conspiratorial criminal, thing going on. You can twist and manipulate anything. I mean, if they were going off of my chats, I mean, what did we see it? What was the case where we saw? Oh no, but I'll just keep going. But yeah, you guys, yeah. I love all of you. You're amazing people.
I have a message at 9:48 and 15 seconds from mommy to Lindsay.
Okay, what is that?
Good morning. How are you doing today? ?
And what did she say in response?
Good. Period. At the gym with the kids.
And what was the date? Was that January 10th?
2023, 9:48, 21 seconds a.m.
So do you have January 10th in front of you, not the 23rd?
Okay. My correction, sir. January 10th, 2023 at 9:48 and 21 seconds.
All right. And what did the mother ask her?
Nice,
Yes.
still sleeping good.
Did she ask her, are you feeling better during the day? And she said, so far, a little bit.
Would you like me to read that, sir?
Yeah.
At January 10th, 2023, 9:53:01 seconds a.m. Are you feeling any better during the day? From mommy to Lindsay.
And go to January 12th, 11:09 in the morning.
Yes, sir.
What did she say? What did Mommy say?
From Mommy to Lindsay, January 12th, 2023, 11:09, 32 seconds a.m. Still feeling a little better, question mark.
And how did she respond? How did Lindsay respond?
A little bit.
And then on January 16th, well, wait a minute, January 14th at 1:05, I think in the afternoon. Can you pull that one up?
Yes, sir. One moment.
Okay. Do you recall where it starts as, I'm waiting for the day, and that would be from Lindsay to her mother.
Can you repeat the time one more time, sir?
1:05
AM or PM?
PM.
And this is on the 14th, sir?
Yes, sir. Yep. January 14th.
Agreed cigarette hash.
I have a message from Lindsay
Maybe
to
not all,
Mommy,
but I
January
feel you.
14th, 2023, 1:05, 13 seconds PM.
Saying,
About the same, period, hanging in there and waiting for the day I wake up and feel me.
Ellipses, we call
so
that.
she says,
by the
waiting
way.
for the day I
Officer.
wake up feeling like me, right?
That's correct, sir.
Okay. And then on the 16th of January, if you can pull that one up. January 16th at 10:20.
I have a message from Lindsay to Mommy, January 16th, 2023, 10:20, 24 seconds AM.
And what did it say?
It was fun, period. Cora and Dawson enjoyed, period.
Now, did it make reference at
Ellipses.
any point in the text that that was a reference to the Cape Codder? Is that in there at all? Do you see it? It was fun, referring to what was fun, if you know.
Not in this particular message, sir.
Okay. And then continuing on, sir, January 18th, would you agree that she inquired of her mother, or the mother asked, are you starting a new med? She said, I did. I started it two nights ago. And that basically the mother was asking her about her medications and how she felt and how she was doing, right?
One moment, sir. I just have to get to that point.
While he's looking for that,
You know what? That's okay, because it's an exhibit and the jurors are going to have it and they can take a look at it. So that's okay. We're good on that.
Okay, don't answer the question.
No, you don't have to answer. That's all right.
Okay, sir.
while I'm thinking about it, just because I don't want to forget, Bob and I are desperately trying to do, because we said we have this mental health awareness day. For all of you who've been sending all the things, and everyone who's following us knows what this is about, but we have to get our mental health professionals together for tomorrow. We both have people we've been trying. I know there are mental health professionals in our chat who have been willing to come on with us. So email us at a truecrimepod.com or message Bob or do something. If you're a mental health professional indicating your profession and that you're willing to come on tomorrow, I think it's going to have to be, I think our plan is late afternoon start tomorrow. So if you're available and you're a mental health professional, let us know. Obviously, all of you who appear who are going to be there will have the opportunity to leave your messages or send your emails. We're going to be doing it on the go. I don't know if we're going to have a call-in option as well but we do want to have mental health professionals on with us. All right, so let's get back to it.
Now, on January 24th, District Attorney asked you about the Google searches, Googling 3V restaurant, looking at the distance from the house to 3V restaurant, looking up menus. You recall answering her questions on that?
He must
do,
get
sir.
to the end, yes.
And you're familiar also prior to that on the same day that she had taken the baby to a doctor and that Pat texted her and asked basically, you know, how did it work out? Do you recall that?
I recall the doctor's appointment. I don't recall the text.
Do you recall that Lindsay sent a picture of her and her children taken that afternoon?
I recall the snowman photo.
I'm sorry?
I recall the snowman photo.
Okay. And that was on the 24th of January, right?
It was, sir.
Do you recall that Pat
Horrible mother,
texted
horrible.
back and said something like, "Oh, wow, you're a good mom"? Do you recall that?
I don't recall the text.
One of the other searches that you did would be,
All right, stand by, guys, after the trial wraps for anyone, because I know we've got a lot of people here today. A lot of you are also on X, so I don't know who's hearing what, but to tell you how to get your story to us for tomorrow's Mental Health Live, I'll get into all of it.
are you aware that there were searches for medical, such as questions regarding bipolar symptoms, psychosis? Can you be in DKA without high blood sugar? Page after page after page, trazodone, what is the effect of trazodone? Wellbutrin, how do you feel on trazodone? Ativan addiction, Prozac, trazone, going on and on and on. You guys saw this on her search on her phone, the Celebrate, right?
I recall those searches, sir.
Okay. Could I offer this, Your Honor? This would be medical searches on her phone.
Any objection?
No.
All right, that may be admitted.
Exhibit 239.
Great, thank you.
Do you recall, sir, that there was also a search for schizophrenia? I'll say that.
Not specifically.
Well, if I approach you, sir, and your extraction report, does that refresh your memory that there would be a search on her phone for schizophrenia?
There's still one more after this guy.
Yes, sir.
Okay, what was the date of that search?
January 19th, 2023, 9:58:01 seconds a.m.
Okay, put that right here for a minute. How about psychosis? Did she search for psychosis as well?
If I may.
Of course.
There is a keyword search in psychosis in a Google search.
That would be a keyword search that you said in a Google search on the January 20th?
January 20th, 2023, 8:39 and 0 seconds p.m.
Okay. Then
You don't search
was there-
schizophrenia if you're
was there
not
also
hearing
a
voices.
search for Seroquel?
Seroquel is part of a search, yes.
And what was the rest of the search?
On Seroquel, feel like I can't have a conversation.
Okay. And it goes on a number of other inquiries as well.
Jesus.
correct? Dealing with Seroquel.
That's correct, sir.
This shit should be
And then
illegal.
further,
You know, that's the thing, guys. It really is a game. It really is a game, trials. They just pick and choose to put on whatever they want. And then it's up to a good lawyer to be like, wait a minute, you're lying about everything, and here's why. And the judge just sit there, he's the referee of this game. This bullshit fucking game. There needs to be more gatekeeping before cases can go. Not a ham sandwich, okay? Get fucking rid of the ham sandwiches. We need real probable cause determinations. Probable cause needs to be revised for the purposes of charging and allowing to bring a human being to trial when the outcome of 99% of the trials are guilty verdicts, and you've got innocent people left and right being, released from prison as wrongfully convicted. It needs to change. It needs to fucking change. On Seroquel, I feel like I can't even talk Come the fuck on, people.
It goes on a number of other inquiries as well, correct? Dealing with Seroquel.
That's correct, sir.
And then further, do you recall that there were a number of pages where she Googled and was inquiring about suicide?
Yes, sir.
And can you tell us when she was Googling suicide?
December 29th, 2022, 1:02:14 seconds p.m.
And would you agree that she also Googled on a number of occasions sleep?
Sleep is one keyword and part of a Google search, correct?
And then there's a number of pages that are attached to that dealing with the search for sleep, correct?
Keep coming.
That's correct, sir.
And do you know the time frame that we're talking about from the Celebrate search?
Multiple entries, sir. Majority of them are in January of 2023.
Okay. Also, a much larger package of searches for trazodone. Is that correct?
Yes, sir. Trazodone is one keyword as part of multiple Google searches.
Zoloft?
Correct.
What's the time frame?
If I may just remove this, sir.
Yeah, sure.
Earliest entry is December 31st, 2022, 4:07:48 seconds p.m. Last entry, all on the same date, December 31st, 2022, 7:06:39 seconds p.m.
Okay.
Oh, this is all just fake. She was just
Also,
bullshitting.
on her phone, this is
Sorry, I was off the screen to mute myself. All these searches right before she puts herself checks herself in.
search for benzo withdrawals, right?
Yes, sir. Benzo is listed as a keyword as part of another search.
Also, after benzo, it says withdrawals, right?
Correct.
And what's the time frame for that, please?
January 20th, 2023, 8:11:57 seconds p.m.
Okay. And also a search for Wellbutrin.
Yes, sir. Wellbutrin is a keyword as part of a Google search.
Does it say what the time frame is?
It does.
What is it?
January 16th, 2023, 9:14:47 seconds a.m.
Okay. And a search for McLean.
Correct, sir. McLean is part of a keyword of a Google search.
What's the time frame?
December 29th, 2022, 8:52:37 seconds a.m.
Someone full of shit. She was obsessively
Also a
focusing
search
on it
for
a lot.
insomnia.
Yes, sir. Insomnia is part of a keyword of a Google search.
What's the time frame?
December 31st, 2022, 7:12:58 seconds p.m.
That's December 21st, did you say? 31st.
December 31st, 2022, sir.
And there is a search for keyword ketamine. Ketamine.
Yes, sir. Ketamine is part of a Google search. It's a keyword within the Google search.
What's the time frame?
For this entry, January 20th, 2023, 8:39:0 seconds p.m.
There's also a search pulled up on Celebrate for Lamictal.
Yes, the word Lamictal is part of a Google search.
And what's the time frame?
January 16th, 2023, 9:23:13 seconds a.m.
Okay. Is there also a keyword search for postpartum and Google searches for postpartum depression and various aspects of postpartum?
Yes, sir.
And what's the time frame for us?
They all occur within January of 2023, with the earliest date being the 11th of January 2023 and proceeding all the way to the 19th of January 2023.
And keyword benzo. Is that on the celebrate record for Lindsay's cell phone?
It is, sir.
Can you tell us what the time frame is?
Sir, would you like it for the first entry or all the entries?
Give me the ideal, the bracket, starting on when, ending on when. We don't have to go through all of them.
The earliest entry appears to be December 6th, 2022, 9:17:05 seconds a.m., with the last entry being January 20th, 2023, 8:13:48 seconds p.m.
And search for bipolar. That was on her
Special
phone.
guest coming.
Keyword bipolar is part of a Google
Coming.
search, correct?
Bracketed in. What's the time that it started? When did it end?
The earliest entry is from this report is December 29th, 2022, 9 a.m., 37 seconds. And the last entry is January 13th, 2023, 1:38:42 seconds p.m.
And clonazepam was a search as well, correct?
That's correct, sir.
And can you just give me an idea, what's the time frame on that?
All of the searches in this report indicate January 18th, 2023, in the morning hours from 11:26 a.m. to 11:27 a.m.
Okay. And the next one would be Ativan. See what it says Ativan? What's the first? Just give me the first month. What's the stat? Search for Ativan.
The earliest time frame, sir? December 31st, 2022, 7:06:30 seconds p.m.
Okay. Next one would be amitriptyline, correct? Okay.
I'm not sure on the pronunciation, but it appears to be that way.
Okay. And when was the amitriptyline search? When did it start? When did it end?
January 16th, 2023, 11:01:28 seconds a.m., with the last entry being January 23rd, 2023, 8:17:58 seconds p.m.
And then on January 20th, 2023, was she searching intrusive?
That's correct.
Okay. And then finally, sir, on January 19th of 2023, was she searching hallucinations?
Yes, sir. 10:33:49 seconds a.m.
Sir, I would offer these.
I could just look them over.
Sure, yeah.
You're welcome, sir.
No objection.
Okay, those may be admitted. Do you want to admit it's individual?
Is one individual or all one? I don't care.
Ooh, why don't we do that? I hate to do this to you. Why don't we do it individually? Just might be easier down the road.
Okay.
My beautiful and brilliant daughter.
Hey
Cameron Motta.
guys.
I might have blooping time. Let's see. Yeah.
Disagree with me is this. So
Was this for her to mark all the exhibits?
disagree with me is another extraction search on her phone.
Yes, sir. It's a supplemental report for searched items.
And looking at that, Ken, basically there are a number of search terms in there, such as pre-made goodie bags, and that would have been on December 31st. Is that right?
The birthday party.
Yes, sir.
All right. And what's the next one underneath that would be on December 31st?
Child with bloated belly and lethargy.
How about the next one on December 31st?
Children's Motrin stores.
What about the next one on the 31st?
Children's Motrin.
Next one.
Is children's town hall the same as infants?
Next one.
6-month-old whale windows.
That would be WALE, whatever that means.
Yes, sir.
Month-old. Okay. Next one.
Earth's best organic baby food.
Next one.
Earth's best organic infant.
Next one.
Earth's best organic infant formula.
Next one.
Nova Plymouth, NOVA.
Next one.
Best kids movies.
Next one.
Nova Trampoline Lark.
Next one.
Unicorn Picture.
Oh no, she's seeing unicorns,
Next one.
guys.
If you can.
Yes, sir. Unicorn Picture Free Coloring.
Just read them right down. Just
Yes, sir.
Just rip right through it.
Paw Patrol saves. I'll spell it. Paw Patrol saves the MEREKR. Twin Girls Bed. Cape Cod Resort. How much formula for 8 MINTH? Chuck E. Cheese. Chuck E. Cheese. Children's Motrin. Children's Motrin stores. ADC Temple Touch Thermometer.
Can I just interrupt you?
Yes,
What
sir.
do we have to for date right now?
The last item I read was ADC Temple Touch Thermometer, sir, and the date was January 17th, 2023, time 2:19:03 seconds p.m.
Okay. I just want to get a frame on the time. Okay,
Yes, sir.
Go ahead. Finish that up.
8-month milestones. Fluffy slime recipe. Fluffy slime recipe. UTI symptoms children. Kids Miralax. Miralax for kids.
And what was the date on that?
The last date on the page for Miralax for kids, January 24th, 2023, 4:47:31 seconds p.m.
Yeah, go ahead. Finish these three more.
Yes, sir. CVS Pharmacy, Pedialax.
Thank you, sir. I'd offer this, Judge.
All right, that may be admitted. Yeah, 261. That's
And then finally, sir, approaching you with.
It was January 24th.
You can recognize that document, right?
Yes, sir.
Right. And what is that?
It
It doesn't have the thing, the header on the top. That's all.
It's a supplemental report, sir, and appears to be text messages.
Okay. Are you able to know when the photograph of the two kids and the snowman was sent to Pat by Lindsay? You know when? Was it on the 24th? If you know.
I would have to look at the extraction.
So, understanding jury would be able to be looking at the photo and has a little history. If we look at this report, you see where it says Lindsay owner, and then over here it says Cutie.
Yes, sir.
So is that from Pat to Lindsay?
That's correct.
And what's the date and the time?
January 24th, 2023, 8:19:45 seconds a.m.
Okay. And what's the next one that you see? And just say to us, like, it's Pat to Lindsay or Lindsay to Pat, and what is the message? You don't have to go through all the notes.
Yes, sir. Next item, do you want me to read the date, sir?
Yeah, sure.
Next item, January 24th, 2023, 8:36, 17 seconds a.m. Lindsay to Pat, loved an image, which is a reflection that someone used the feature within iMessage to like an image.
Like an image, like a photograph, right?
Correct, sir.
Yep. What else?
Want me to keep going?
Sure.
It's like I'm doing good.
January 24th, 2023, 8:42, 16 seconds a.m. From Patrick to Lindsay, how's it going?
And you know what? If it's the same date, rather than taking the time, just go right down and read the messages. That would
Receive, sir.
The time frame.
The date is the same for all the messages. From Patrick to Lindsay, how's it going? Lindsay to Patrick, good. Lindsay to Patrick, okay, her urine looked good, so nothing going wrong with her kidneys, phew. Patrick to Lindsay, good, with a smiley face. Lindsay to Patrick, no message content. Patrick to Lindsay, oh wow. Patrick to Lindsay, you're a good mama. Lindsay to Patrick, smiley face with hearts. Lindsay to Patrick, blank. Patrick to Lindsay, laughed at an image. Lindsay to Patrick, any chance you want to do takeout from 3V, period, period, period. I didn't cook anything, period, period, period. It's been a long day. Smiley face. Patrick to Lindsay, yeah, smiley face. Lindsay to Patrick, okie dokie, smiley face.
Okay. I'd offer that, Your Honor. Thank you.
Yes, sir.
Your Honor, these text messages are in evidence as Exhibit 23.
This.
I'll allow that. Thank you, Mike.
He's like, no, I want this then. So knock it off. Like,
260 grams.
the Commonwealth, he keeps trying to take small portions that have the details he wants and admit those into evidence. And the Commonwealth just keeps trying to say, no, it's in a bigger thing. Turn the trial up. What are you guys asking? Hold on, let me check.
Finally, District Attorney spent some time asking you about modifications to a photograph, and I think it was of the little baby. You recall that line of questioning?
Yes, sir.
What did that mean? Does that mean that someone, or Lindsay or someone on her phone, changed the photograph of the little baby? Is that what that means?
It means that the photo was edited in some fashion.
So that could be like coloring?
It could be a variety of things.
Like what?
As I indicated in my earlier testimony, it could be that someone took a live photo, and instead of having it be a live photo, which is a multiple burst of images, they took it down to just a single photo.
Anything else that can be modified?
Multiple things, but from the extraction, that's the only thing I was able to determine.
So you weren't involved in the search of the Clancy house on the 24th, 25th, right?
Wait, so you mean she took a picture and it was a live picture, and then she went through and found the best version of it to send? I mean, are you about to play this live picture and there's like screaming and yelling in the background? Like, stand there for the effing picture, you horrible children. And then she picked the one, still photo and sent that? Because if that's not what's happening, then just go to hell, Commonwealth. And I'm sure that's obviously not what's happening.
No, sir.
Were you aware of the Clancy house on the... So you weren't involved in the search of the Clancy house on the 24th, 25th, right?
No, sir.
Were you aware that there are photographs of the kids hanging in virtually every room, kitchen, living room, bedrooms? Did you know that as an investigator on this case?
Sir, I was not involved in the search.
You know that there were dozens and dozens of photograph albums, little babies, all over the house. Did you know that?
I was not aware of that, sir.
Thank you.
Commonwealth redirect?
Oh, done. Dawson redirect.
All of the exhibits that defense counsel just put in about the searches for psychosis or certain drugs, are those all available in the disc exhibit 236 in some of those reports where you can search the word and all of those mentions will come up?
Yes.
Don't act like you put it into evidence. Don't act like that's what you just did. Because you didn't mention it. You snuck it into like 10,000 other, or what did he say, 100,000, 80,000? I don't know.
Sir, an exhibit 258.
I can't stand to look at her face. I can't stand to look at either.
The search is about psychosis. Some of those searches were for psychosis symptoms on January 19, 2023. Is that correct?
That's correct.
So the person using the phone looking it up was looking up to find out what the symptoms of someone would be experiencing if they had psychosis, correct?
It's a keyword search for psychosis symptoms.
Shut up, scumbag. That's what all of us do. She's acting like that Lindsay was searching so she could fake psychosis symptoms. Then why didn't she fake psychosis symptoms better? Why in the hell are they all saying she had no symptoms of psychosis?
Right. And when I think, as you were saying, that's what everyone does. If you could look something up when you're feeling, oh, I think I have bronchitis. What are the symptoms of bronchitis?
I've already looked it up. What are the symptoms of psychosis? What are the symptoms that tell you that a possible episode or psychotic episode could be coming? Warning signs? This is just too much. Too much. No one is following your logic, Commonwealth. You're the only one seeing it their way. I think even if people who are seeing her as guilty, are they now saying, oh my gosh, she looked up the symptoms to fake it and then decided not to fake it until afterwards. I think somebody put up a comment earlier. I wish I could find it again. It was like, all right, so you wanted to pretend to do something, but then you forgot to pretend to do it. Oh, about the psychopath. So you were gonna fake being a psychopath, but then you forgot to pretend to be a psychopath so that everybody thought you were fine. Okay, so you looked up the symptoms of psychosis so you could feign the symptoms of psychosis, but then forgot to feign those symptoms such that nobody thought you were having them ever. Okay.
You were asking questions about the chats between Lindsay and her mother in Exhibit 238. Correct?
Yes, ma'am.
There's a text message from her mother to Lindsay on January 19th, 2023, which states, I'll bring it Saturday, never know what treasures I'll find in the attic, correct?
That's correct, ma'am.
Seeming to indicate that her mother is going to visit her that Saturday, correct? From the text message content.
It's an inference.
There's also a text message from Lindsay's mother to Lindsay on January 22nd, which would have 2023, which would have been the Sunday after the Saturday visit, in which her mother says, enjoyed seeing everyone this weekend. Nice to see you doing better.
That's correct.
Oh no. What is the point of this? Is there a point?
This text thread was also brought up during Patrick's, or at least this day was brought up during Patrick's testimony as well.
I have nothing further.
Strengthen.
I think she just, the reason that we can't follow the point she's trying to get across is because she's making them as if, the jury lacks intelligence. Because when we're looking at what she's saying and we're using our reasoning, we're like, okay, the jury's going to see what you're trying to do in 2 seconds and realize that's not the most plausible explanation. But the way that she's laying out, you know, this prosecution is just, let me just do this in the most, let me plant the seed, and then that's all I have to do because you guys don't have any reasoning and can't figure out why someone would be doing a Google search or sending a text message. Like,
Yeah.
it's what she's been doing all trial.
Yeah.
Sprague?
Just very briefly, kind of like a housekeeping thing, if I could, Judge. I'm approaching you with a number of text messages. Would you agree with me? Again, this came up on Lindsay's phone, and it would be text messages between Patrick Clancy and Lindsay. Kind of flip through them all. Trust me, one of the others.
Yes, sir.
Flip through them or trust me, one or the other. It's a version of both.
He's literally.
All right.
That's correct, sir.
And then finally, I'm handing you, again, extractions from Lindsay's phone that you can flip through them if you wish, would be between Lindsay and Sue Clancy, her mother-in-law, Patrick's mother. It said Sue Clancy.
That's correct, sir.
Okay. I'd offer these two, Your Honor.
Objection.
If I can see counsel sidebar.
Look at him. He's so frustrated, but he does a really good job of. She just wants to object. What? Why do you want to object, State? Well, because we don't want like a full picture. We want the little piece of the
That's all I
picture.
have. Thank you, sir.
All right. Attorney Sprague, anything further?
No, Your Honor.
All right, thank you, sir. You may step down.
Thank you.
All right, going to lunch.
So we're gonna take in the next witness. My instructions are the same. During the break, don't talk about this case, don't do any research, don't read anything, don't listen to anything. And then I'll see you back here about 2 o'clock. Okay, thank you.
Court, all rise. Jurors, kindly close your notebooks. Next one in chairs, please. This way, please.
Full health. Actually, as full great judge, I apologize. When I introduced the records from South Shore Health, actually I put in a cover page and the wrong page that does not reference the actual medical record that I have. So if you have any objection to the substitute status, it's the appointment.
Right. So I'm sorry, I just missed the part where you said it's different than what you submitted.
Yeah, what I submitted is just like a cover letter and some other things. I thought I submitted the medical record.
Oh, no objection.
All right, so you want to substitute those?
Yeah, sure.
Is it from this new batch?
Thank you.
All right, thank you. All right, so we'll be in recess till about 2 o'clock.
Court, all rise.
Yesterday.
Time on the
Sure.
10th.
9:48.
Correct.
All right. Well, say hi to Cam, then she's going to run my errand because she feels like she hasn't watched enough for today to jump right in.
I'm going to study up on what I missed while we go. Scout left her backpack at home. So I'm going to run it over there and then I'll hop on after lunch.
All right. Talk amongst yourself for about 3 minutes. Love you. All right. Yeah, so Scout left her volleyball backpack here. I kind of thought they'd be done by the time we went to lunch and that I could take in Cam out to lunch, but obviously that did not work out. So let's see what you guys are saying. All right. Dandy B. Moore wants a quick summary for those of us who are working. So there was bullshit. Then there were lies. Then there was some fuckery. No, all right. But seriously, we just had basically the computer and the phone people laying foundation for whoever this next witness is, getting in the phone history and the search on the computer history, trying to imply that she was searching for ways to commit suicide in 2022, including jumping off of a high place and the type of injuries you could get. So I think the dog was just crying. Maybe not. Oh yeah, he is. Chat, help him out with the summary. I'll be right back. Grab the dog. All right, sorry guys. So, where was I at on the on the update here? Got past the lies and the fuckery. I mean, it's bizarre because it's been hours. And I feel like we got like through nothing. So there's been two witnesses. The witness for that did the search on the computers, who out of all the computers and all the things they could have searched and all the evidence they could have found, they found that in August of 2022, there was a search specifically tied to the country artist who committed suicide. And then from there to a suicide page, from there, how he committed suicide, and then details about how he jumped from a high place. And when you jump from a high place, this is the type of injuries you can find. Then Reddington got on the stand and proved that, first of all, Lindsay Clancy wasn't even home, for God's sakes. She was at a doctor's appointment that started at 9:45, ultimately, when we get it to it at the end of the day. That Patrick was logged into, for whatever reason, her Facebook was open on Patrick's computer, that in the same amount of time, Patrick got on and checked his email. Then the Commonwealth gets up there and be like, well, you don't know. She could have been sitting there, and then he could have gotten up, and she could have sat down, and she could have got up, and he could have sat down, and she could have come back. And then that explains this whole scenario. And the doctor's appointment was only 4 minutes away. So, who cares? Then we find out the appointment was actually like 9:45. And the searching started, I think, at 9:47. Then we get the computer guy who, out of all the searches, no, the phone guy, out of all the texts and all the possible searches on the cell and all the possible texts she could have, she told her mom she wasn't feeling so great. Sent Patrick some messages about the kid and the doctor. But I mean, their primary point with the first witness was the search, the map search, the Google map search that Lindsay looked up the menu for the restaurant, looked up CVS's, and if they've got the medicine she's looking for, called a CVS maybe. I can't even remember anymore. I think so. Hi, doggy. Come here. Come on. Yeah. Oh, no. So our dog, by the way, this past, it seems like the past 2 weeks, this has all happened. So Cameron left food in her room that she was in the middle of eating, went out, went back in. The dog ate all of it. He does not usually do that. Just downing our food like what? No, that is not a thing he does. And then same thing in Scout's room. And then the other day when Cam came back, cause she's pretty much moved out for college. Oh, I gotta switch the banner. Yes, I do. Where is it? Yeah, here we go. Well, that one will show. There we go. Yeah. So I forget what happened. Oh, I had to stop and get the kids after volleyball, they wanted fast food. So, or I was getting my father-in-law something. I can't remember. So I just grabbed Cameron something to eat because I wasn't going to have time to make dinner. Oh, it was the day that we had the double live and I was on with Bob and then we did the members only. Anyway, she was asleep, so I didn't wake her. So rolled up in a bag, but I left on the floor because all of her, shit's gone. There's nothing in her bedroom but her bed. And when she woke up, and I specifically closed the door, I'm like, that dog's no. Whatever the fuck he's got going on, he's been doing, that's not happening. So I specifically closed the door. And then she came out while I was on the live to tell me about this horrible dream that she had. And she went back in and he had torn open the bag, eaten an entire chicken sandwich that was in another bag. She didn't see the wrapper for, but wasn't sure. An entire I got a large cheese curds from this place because I'm like, sometimes I like to snatch the cheese curds when the kids are eating it. They're like, oh, I'm not really eating cheese curds, right? If I just take a couple of theirs. So I get the large because I was like, in case mommy wants to eat some of them. He ate the entire fucking thing. So now anytime there's like food, I'm like, what is this guy gonna do? He's just eating all the food. Yeah, I'm talking about you. Where'd you go? Huh? What are you up to? Yeah, I'm talking about you. Naughty Nanook. So, I don't know. All right, sorry. I went totally off script. He definitely is upset that Bob's gone. He's upset. But this was before Bob left. So, don't get it twisted. Bob was the first couple times. The last time, yeah, Bob was gone. The whole eating it out of the bag. Yeah, Bob wasn't here, you know. So, I don't know. I mean, I think he's just a little hungry hippo. Like it's just unusual that he's taking food. Like usually we can leave food on the table like on the kitchen counter or on the kitchen table, and this guy is not going to like jump up and eat it. But he, I think, jumped onto her bed and took it the first time. So I don't know. All right, let me get back to your questions. Okay. Debbie, welcome. Dandy, I don't think I even gave a good quick summary. Nothing about it was quick. It jumped around. It was very disjointed. Hopefully it gave you something. Appreciate you. And appreciate you guys with your jewels. Love the jewels. I am unseated. It says Massachusetts state that gave America the witch trials. Yep. Got some more jewels. Love the support we get with the jewels. Bob's like, I was telling Bob yesterday, dude, don't spend an hour reading the jewels. Like the people send the jewels when they feel it because they know that's a way of, yes, I understand it's money. It's a way of, expressing themselves and contributing to us at the same time. But you can't spend an hour reading everybody's jewel that they sent forever ago. Like put them up on screen, thank people for the jewels. So hopefully y'all don't think that's rude, but that's the way I'm doing it. So damn Gina said, I emailed the link to Lindsay's parents GoFundMe. Trace, if you can send that to me, that would be amazing. We really need to get it because remember, like when Bob started all this, I was not involved, so I don't have access to all the things. I don't have the email doesn't come to me. Usually if something comes, Tracy sends it to me. The insider at Defense Diaries goes directly to Bob. I could get the True Crime Pod. I don't know why I haven't set that one up. I just, it's a matter of just like setting it up. But the insider at defensediaries.com goes directly to Bob. And that's, I'm not linked to that. So I'll get that up. But apparently there is a link for Lindsay's parents GoFundMe, which somebody asked earlier today. So thank you, damn Gina. More wonderful, thoughtful, generous jewels. Britt Ander became a member. Welcome. Mary Swampy says, tell us how you really feel, Allie. LOL. Yeah, that was during a well-deserved rant. I can tell you that much. And Jennifer, having the same sentiment, said, I love you. Preach it. Thank you for your generosity. Thank you for the jewel generosity. We got another new member. Harder through the glass. Harder through the glass. Okay, so doing that right. Thank you. Welcome. And I'm sorry. I'm the worst at butchering names. It's not even polite. The virtual drawer says, yes, baby front seat. If no back seat, back is full with other kids. Okay, right. If in front seat with a rear facing car seat, pass airbag turned off, the passenger seat airbag is turned off, a truck comes to mind. Yeah, no, I didn't mean to say like who's putting a baby in the front seat, because sometimes I guess there are reasons for that. But yeah, the passenger the airbag is off, you know. So, and Outlaw Pete gifted 5 DD memberships. Thank you and welcome to those people. Cigarette Hush says a narcissist can twist and manipulate anything. All prosecutors are narcissists. I was with her on the first part of the sentence, or Cigarette Hush, I'm with you on the first part, and I just feel like I can't say all prosecutors are narcissists, but I hear what you're saying. Real Tea with Krista says, you're not so bad yourself, Judy. I was praising the chat, so she gave me a praise back. Appreciate it. The stay-at-home juror. And I might have read this, but let's read it again because it's how we're all feeling. This is some bullshit. I literally use Apple Maps every time I order takeout. The Commonwealth basically laid out how Lindsay used the app step by step, exactly how I would to find the website and the phone number. I mean, it's just like, come the fuck on, Commonwealth. And I actually would love to hear from somebody who sees this same evidence and says, the stuff we're dealing with today specifically, and says, you know, I think that's planning. We had one, and I wanted us to give her space for that position, but then I kind of poo-pooed it immediately. Thanks for all the jewels, guys. For the demonetization fund. Better not be demonetized. Jammin'. I am unseated also says, this case is so very anti-woman. I am sick of it. Who can we take a protest to? Governor, district attorney, senator, president? Honor and respect. You know, nobody. We're screaming into the void over here. But I guess it would be like your local representatives. That's who needs to know that that's who's supposed to be sitting in the Senate, in the House, ultimately saying what in the hell their people want. And then they get that information from the local representatives. So if we, the people, are telling our local representatives, we want criminal justice reform. We want criminal justice reform. We want criminal justice reform, and spelling out what that reform is, as you know, but yeah, I mean, legislation would have to pass through each state, if not the federal rules of evidence, to change what the hell goes on in a courtroom. It's crazy. It's crazy. Amy's late, or Amy's lattes, or Amy Slater. Amy Slates. Oh my gosh, Amy, just take your membership back after that butchery. I mean, I feel like there's a pair of cheaters here somewhere. Maybe these work. It's like, you know, welcome, Amy Slates. Welcome. So, and Lizzie is the one that I think made this comment. I could be. Oh, no, it wasn't Lizzie. So Lizzie says, if you want an infant seat in the front, you have to turn off the airbags. Accurate. But there's one coming. All right, Cameron wants to see what I want to eat. Hold on. Hold on, people. Ooh, we're getting soup and chicken Caesar salad. So, all right, where was I? Thanks for the generous trophy action. Kelly Steffi, the Bopsy twins should just say 227 didn't happen, for fuck's sake. I put that up before. I honestly did feel like that's where they were going. And I might have gotten everybody else. Oh, Mermaid Mary. I went to text Bob when I put it up, but now I can't remember if I saw a text from him and then never said that part. So, oh. What the heck? Hold on. Well, it's too late. Well, stand by. Stand by. Is this it? No. No. Ay. Oy, oy, oy. Hold on. Need to send my husband something. Is this it? No. Sorry, guys. Let's see. I think this is it. There it is. There it is. I have to send him the thumbnail of me and Cam. Now I got to take off the day 10 because it's day. So I'm just going to do you guys know that the phone now has this like cleanup feature of a picture, and I just run my finger over it and day 10 disappears. And I will save this as a duplicate because it's actually different. And now I'll send it to Bob. Okay. And then remind him about Mary RN. Wait, didn't I just send you this? Damn it. Why is it acting like I'm not sending him this? Sorry, this is awful. You guys have to bear with me. So weird. All right, sent him that. And then I'm not sure why I keep sending over and over again. And it's going in the wrong place. Okay. All right. Okay. Done and done. Sorry. So Reddington will absolutely, Thorne PhD asks, will Red ask for a directed verdict? And I think I looked this up before, and you can ask for a directed verdict. No, maybe not a directed verdict. I don't know. I know you can ask for judgment at the end, like after he puts on his case for a finding of guilty but not criminally responsible. I don't know if he actually will ask for a directed verdict because he hasn't put on his case yet to establish. All we have so far is that she was suffering from a mental disease or defect. We don't have any expert testimony that puts that shows that she was either didn't appreciate the wrongfulness of her actions or couldn't conform her conduct to the law. So I guess we'll see, because this is different. You know, I've never seen this type of scenario. So I guess we'll have to see. Very good question, Thorne PhD. You know, typically we always ask for a directed verdict. So that was like my first instinct. But then I'm like, wait a minute, that's not what's happening in this case. A bow for a bow. As the Commonwealth is hedging bets on defense case, does it affect judgment of acquittal? Ah, look at that. See, that's what I was getting at. They haven't even touched disproving. Also, inviting everyone to my house for a journal burning bonfire. Talk about weaponizing tools, right? I mean, seriously. So, judgment of acquittal, I don't think that you can ask for technically an acquittal here because what they're asking for is a finding of guilty but not criminally responsible. But I do think that you can ask for that as a judgment. I just don't know if it's as a directed verdict in the middle or at the end. So we'll have to see. But that goes hand in hand with Thorne's question. Very, very, you guys are so smart. You guys are just so smart. Stacy notes, I think I welcomed you before, but I have just welcomed you again. And I think that's everything. Pretty sure. No, I think yeah, because I remember struggling with the name, Pantuffle. What does map search prove? I get my phone numbers, menus, times for businesses using maps more than anyone else. Thank you for covering. Agreed. Agreed. Oh, yes. Yes. I forgot. I better get in. Virtual drawer reminds me. Yes, yes, yes. I'm going. Okay, I'm gonna call him right now. Tell him I'm about to send you the thingy. Hold on, guys. Stand by. That. Sorry, it just worked. He verified me. We're back. We got access. I got my access. Thanks for the reminder, virtual drawer. So I'm going to. So what should I do for a poll? Let's see. I mean, we're not done yet. So I don't even remember. So while I'm in here, right? Like I go in. No, that's day 13. To the content. And then there's like a button here to do a poll, right? Somebody told me this before. Let me try. Oh, that's not it. Oh, I know. I'm wonderful. Gotta love me. All right, I think I start here. Oh, yeah, I found it. Start a poll. All right, so whenever we're actually ready to do it, I've got it up and ready to go. Thank you. Thank you. Welcome, Hannah Probic. Porobic. Hannah Porobic. Welcome. Now I think I've gotten everybody. I'll just keep going just to make sure from this morning. I mean, yesterday, but I must have left some people out or I wasn't reading it right. More jewels from this morning. So generous with your jewels. Thank you very much. And that's where the question was about the GoFundMe. So apparently there is one. Let me see if Tracy sent me. Oh, Tracy verified me. I don't even. Thanks, Tracy. Bob didn't even have to do it this whole time. I just was choosing a different, like I was choosing send me the one-time pass, whatever. It doesn't matter. Thanks. Got way more jewels. Love you guys. Thanks for the jewels. And then BMD Nuts X2 says fuckwits is a good name for the prosecutors. I couldn't agree more. I'll blow this little thing up. Oh, look at that dog. Oh, so cute. Kelly Durazio Healy says, just sad. She was failed terribly. Hard to watch. I mean, it really is. It really is. And thanks for your generosity. Richard Ferry says, I just spoke to a woman who says Lindsay Clancy is not guilty because, yes. I mean, sometimes Dunning-Kruger and cognitive dissidence get the right result. I mean, it's bizarre that people still think that. And we're trying not to give it air. It's hard. It's stupid. It's not true. I'm allowing room and space for everybody's positions and feelings on this, except that one. Sorry. And I know that you're not holding that position, Richard. I was just saying, like, overall. Lana Dawn, welcome. Welcome, new members. Thanks again. More jewels from everybody. Stitched and Solved says, if anything was overheard while she was inpatient by police, can they then share that information with the Commonwealth and use it against her, or is it privileged? So if they overheard, her speaking to her doctor, that would have, patient doctor privilege, which they could overcome. But if her lawyer was in there or the expert for the lawyer, they would not be able to use it against her. They might hear it and secretly share it, but they can't use it against her. Very good question. And then Carrie New, member for 5 months, are JMOLs only allowed in civil or also criminal? Judgment JMOLs. Judgment is a matter of law. So, which here they would, we just have a different terminology for it. It's not called the same thing, but in essence, yes. But and that's why we've been kind of talking about it and I had looked it up before and I just don't remember, like, as I sit here right now. But I saw something about seeking a judgment by the judge, sort of like a judgment of acquittal, but instead of acquittal, it's of a finding of guilty but not criminally responsible. So I suspect what he'll do is make a half-assed argument for a directed verdict, a directed finding of not guilty but not criminally responsible now, maybe just to preserve the record, and then again at the end, and maybe he won't, but we'll have to see. But you guys are all asking very, very good questions. Julie Jensen says, is there an option on the verdict sheet that she could be not guilty and go home? There's always that option. on the verdict sheet. But I think you're only going to find 2 arguments presented to the jury. Finding her guilty or of a lesser included, or finding her not guilty. I mean, guilty, but not criminally responsible, because the defense has already stipulated that she committed the acts. So, but yeah, it'll be on the verdict sheet. So I know what you guys are thinking about jury nullification. The jurors just want to say not guilty. They can do it. Technically, legally, every way, they can do it. No one's going to be asking them to do it. I'd be shocked if that happened. Like there's no way. I can't imagine a set of circumstances where that can happen when the defendant's saying that she did it. And I do think that the defense will still ask for lessers than first degree. You at least have, like that this wasn't there was no premeditation, even if as an alternative. So I do think the defense will ask for lessers, but I don't know. So not criminally responsible in here is guilty, but not criminally responsible. So that you go to the mental hospital. Not guilty is not guilty. Let's pull up. Now that we've got these chairs like this, it's difficult because we got Cam next to me. Let's see. I'll pull up the statute. Massachusetts. Not. Because I know there's a lot of you who haven't been with us all, obviously, the whole time. Some people who just kind of can pop in and out no matter who they're watching the trial with. So here's the jury instruction for a lack of criminal responsibility. All right. If the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility. Is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove they lacked criminal responsibility. I thought that they called this guilty but not criminally responsible. I could be wrong. Let's keep going. The Commonwealth may meet its burden of proving the defendant was criminally responsible for their conduct in either of 2 ways. The first way is the Commonwealth to prove beyond a reasonable doubt the defendant did not suffer from a mental disease or defect at the time of the alleged offense. That is not relevant. So I'm just going to skip that. The second, because obviously everybody agrees she suffered from a mental disease or defect. Doesn't matter if there's a diagnosis or what. There's no doubt of that here. The second way is the Commonwealth to prove the defendant was criminally responsible for their conduct is for the Commonwealth to prove beyond a reasonable doubt that even if the defendant suffered from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity, and this is a 1. Okay, well, this is the substantial capacity to appreciate the wrongfulness or criminality, that it was a crime, period. That it's wrong or is a crime of their conduct. And meaning the Commonwealth has to prove both and to conform their conduct to the requirements of law, meaning either or works. If they can't establish both beyond a reasonable doubt, here the argument has been to conform her conduct to the requirements of the law, then they can't meet their burden. So to establish the defendant has the capacity to appreciate the wrongfulness or criminality of their conduct, the Commonwealth must prove beyond a reasonable doubt that the defendant appreciated That is, that the defendant knew or understood in some meaningful way that their conduct was either illegal or wrong. Or wrong. To establish the defendant had the substantial capacity to conform their conduct to the law's requirements. And that's really what we're primarily dealing with here. The Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the alleged offense did not deprive the defendant of her ability to behave as the law requires. That is, to obey the law. Okay? So then they have here that if there is evidence that the defendant had a mental disease or defect and consumed drugs or alcohol, continue with supplemental 1. If not, continue here. And I can't remember. I think supplemental 1 is at the end here. Yeah. So we'll be able to see it. To summarize, if the Commonwealth proved beyond a reasonable doubt that the defendant did not have a mental disease or defect at the time of the alleged offense, the Commonwealth has satisfied its burden of proving the defendant was criminally responsible. Alternatively, if the Commonwealth proved beyond a reasonable doubt that even if the defendant did suffer from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of their conduct. So again, it's like, go with God. Do you think it's wrong, but do you know it's criminal? Do you know it's illegal? And to conform their conduct to the requirements of the law, the Commonwealth has satisfied its burden of proving the defendant was criminally responsible. Remember, there's no burden on the defendant to prove that they lacked criminal responsibility at the time of the offense. Rather, the burden is on the Commonwealth to prove beyond a reasonable doubt that both the defendant committed the offense and the defendant was criminally responsible at the time they committed it. If you have a reasonable doubt as to whether the defendant committed any of the required elements of the offense, you must find the defendant not guilty. If you have a reasonable doubt whether the defendant was criminally responsible, so I've been saying it wrong, criminally responsible at the time of the offense, you must find the defendant not guilty by reason of lack of criminal responsibility. Okay, so I don't know why I thought in Massachusetts that they called it guilty but not criminally responsible. So I mean, typically that's what I'm used to. Not guilty by reason of insanity, not guilty by reason of lack of criminal responsibility. So there will also be, I'm assuming, on the I can't imagine any set of circumstances where there's not going to be a straight not guilty option on the verdict sheet. So a defense of lack of criminal responsibility may be raised by, quote, any evidence which, if believed, might create a reasonable doubt concerning the defendant's criminal responsibility at the time of the crime. So, yeah, I do suspect he'll make a motion for directed verdict before his case, and then again at the end. Expert testimony is not always required to raise such a doubt. The defendant may rely on the facts of the case, the Commonwealth witnesses, the testimony of lay witnesses, and any combination. So, yeah, he's definitely going to make one now. And they talk about this Zeizel v. Commonwealth, defendant's psychiatric records, observation of lay witnesses, nature of crime. But that was enough for them to argue it. This court's view has consistently been that where the appropriateness of an insanity instruction is marginal, the better choice would seem to err on the side of giving it, because you don't get this instruction unless you've offered some evidence to raise a lack of criminal responsibility, that there's a mental disease or defect in play. And they're saying, like, err on the side of giving it. Once the issue of insanity has been raised, as it has most assuredly been done here, the Commonwealth must prove beyond a reasonable doubt that the defendant was sane at the time of the crime. Period. The Commonwealth must prove both the defendant's substantial capacity to appreciate the wrongfulness of his conduct and his substantial capacity to conform his conduct to the requirements of the law. Both. The state has to prove both. So just one gets a not guilty by reason of lack of criminal responsibility. The judge may not limit an instruction on the criminal responsibility to specific medical diagnosis raised by the defense psychiatric experts, since the burden of proving insanity remains on the Commonwealth, and the jury is not bound by any particular definition of mental disease or defect. So you've got intoxication. These are the supplemental instructions, and the defense of lack of criminal responsibility. A defendant's lack of criminal responsibility must be due to a mental disease or defect. Intoxication caused by the voluntary consumption of alcohol or drugs is not itself a mental disease or defect. Where a defendant lacks capacity to appreciate the wrongfulness of their conduct or to conform their conduct to the law solely as a result of voluntary intoxication, then the defendant is criminally responsible for their conduct. So there's a however here, okay? And this is important here because I don't know if the state's going to be looking for this. However, the consumption of drugs may the consumption of alcohol or drugs may trigger or intensify, make worse a defendant's pre-existing mental disease or defect. If it does so, the mental disease or defect then causes the defendant to lose their substantial capacity to appreciate the wrongfulness of their conduct or to confirm their conduct to the requirements of the law. The defendant is not criminally responsible for their conduct. Period. There is one exception to the principle just stated. A defendant who loses the substantial capacity I've just described after consuming drugs or alcohol, who knows or has reason to know the consumption would trigger or intensify a mental disease or defect or condition that could cause them to lack capacity, is criminally responsible for their resulting conduct. In deciding what the defendant had reason to know about the consequences of their consumption of drugs or alcohol, you should consider the question solely from the defendant's point of view, including their mental capacity and past experience with drugs and alcohol. But you must keep in mind that where a defendant at the time of the alleged offense was committed had a mental disease or defect that by itself caused the defendant to lack the required substantial capacity, the defendant is not criminally responsible for their conduct, regardless of whether they used or did not use alcohol or drugs. That is true even if the defendant did use alcohol or drugs and the alcohol or drug use made the symptoms of the defendant's mental disease or defect worse, and even if the defendant knew they would make the symptoms worse. So, and then pick up here, if there's no evidence of defendant's knowledge that consumption of drugs or alcohol would trigger or intensify a mental disease or defect. To summarize, in order for the Commonwealth to meet its burden of proving the defendant was criminally responsible at the time of the alleged offense was committed, that is, that the defendant did not lack criminal responsibility at the time, the Commonwealth must prove at least one of the 3 or 4 following facts beyond reasonable doubt. 1, the defendant did not suffer from a mental disease or defect. Or 2, that the defendant did suffer from a mental disease or defect of the alleged offense, and the defendant nonetheless retained the substantial capacity to both appreciate the wrongfulness of their conduct and to conform their conduct to the requirements of law. 3, that the defendant lacked the substantial capacity to appreciate the wrongfulness of their conduct or to conform their conduct to the legal requirements. The defendant's lack of such capacity was solely the result of voluntary intoxication by drugs or alcohol. And then they have this or 4, that the defendant lacked the substantial capacity I have just described due to a combination of mental disease or defect and voluntary consumption of alcohol or drugs, which the defendant knew or should have known use would interact with the defendant's mental disease or defect and cause the defendant to lose such capacity. So, if the Commonwealth has failed to prove at least one of these 3 or 4 facts beyond a reasonable doubt, then you must find the defendant not guilty by reason of lack of criminal responsibility. Now, we're going to get to the consequences of this verdict. But let me just pop in here real quick and see See if we've got any new supers as a result of that. MD 2020 says, wild to live in a country with lawmakers doing everything they can to force women into pregnancy without even remotely addressing needs and lack of resources. Hell, most can't even identify a uterus. I mean, facts. Oh, MD. Ah, MD. All right. Music to My Soul says, Allie, it appears these model. What? Let me check this. Oh my lord. I thought these weren't affected. Again, when you email them to me, to Bob, I don't get them. Let's see. Let me try. 2026. Um uh well, Trace, are you out there? Let me see, wait. Tracy might have said she had to go do something. Oh, I think she's back. Um all right. Let me see. I think I can just pull up the. Oh, wait. Something's coming. All right. She sent it. Let's pull it up. Thanks, Music to My Soul. Share this tab instead. All right. Just so it says that a note to the judge where there is a lack of evidence of criminal responsibility, this instruction. Let's make this bigger. Go this way. Okay. May be given as a standalone instruction prior to the murder instruction or inserted with the murder instruction. In deciding when to give this instruction, a judge may wish to consider whether the defendant has conceded that he committed the crime and whether the only issue for the jury to decide is the defendant's criminal responsibility. I mean, footnote 1 goes to a 2019 case. So, which is obviously here. So we're seeing if there's anything different. So, yeah, it's a legal term. A person's not criminally responsible if either he lacks the substantial capacity to either appreciate the wrongfulness or criminality or to confirm his conduct to the law. Mental disease or defect is still defined the same. So to establish the defendant had a substantial capacity to conform his conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of his ability to behave as the law. It is a little bit different. So if the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity to either appreciate the criminality or wrongfulness of his conduct or to conform his conduct to the requirements of the law. To establish that the defendant had a substantial capacity to conform his conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of his ability to behave as the law requires. That is, to obey the law. So they added this. The word appreciate means to understand rather than merely know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. All right, so they clear that up, that like criminality. All right, so the Commonwealth must prove the defendant knew and understood his conduct was illegal or that it was wrong. It is not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that his conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of his conduct. The defendant must have been able to realize in some meaningful way that his conduct was illegal or wrong. Maybe you do rely on this part as well. Maybe you do. I think you do. Kind of rethinking it. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that you've been presented at this trial. You may consider the facts underlying the crime and the evidence the defendant's actions before and after the crime. You may consider the opinions of any experts who testify and give those opinions whatever weight you think they deserve. I don't know that I love that change because that makes it seem like it's dependent on experts. Huh. I don't think that was the intention, but a defendant's lack of criminal responsibility must be because of a mental disease or defect. All you need to determine as to this issue is whether they have proved beyond a reasonable doubt the defendant did not have a defect at the time. Intoxication caused by voluntary consumption of alcohol is not itself a mental disease or defect. If it was solely as a result of voluntary intoxication and not a form of mental disease or defect, he is criminally responsible. All right. But a mental disease or defect might be caused by or the result from a defendant's past chronic use of alcohol or drugs. Wow, that is a really amazing change because this is something that we've been trying to argue room in Illinois' insanity defense for. Like Massachusetts, at least legislatively, is with it. So also the consumption of alcohol or drugs may trigger or intensify, that is, make worse, a defendant's pre-existing mental disease or defect. If it did so here, the mental disease or defect then caused the defendant to lose the substantial capacity to appreciate criminality or wrongfulness of his conduct or to conform his conduct to the requirements of law. The defendant is not criminally responsible for their conduct. And then it says where there's evidence the defendant knew that intoxication caused by voluntary consumption of drugs would trigger. There's one exception to this principle. A defendant who lost substantial capacity, as I just described, when voluntarily intoxicated by drugs or alcohol, and who knew or had reason to know that his intoxication would trigger or intensify him in a mental disease or defect that could cause him to lack the capacity, is criminally responsible for his resulting conduct. In deciding whether a defendant had reason to know the consequences of his voluntary intoxication from drugs or alcohol, you should consider the question solely from the defendant's point of view, including his mental capacity and past experience with the drugs and alcohol. You must keep in mind that where a defendant, at the time his crime is committed, had a mental disease or defect that is by itself that by itself caused him to lack the required substantial capacity, he is not criminally responsible for his conduct, regardless of whether he used drugs or alcohol. That is true even if he did use alcohol or drugs, and the alcohol and drugs use made his symptoms of his mental disease or defect worse. And even if he knew, they would make his symptoms worse. It seems like a really hard thing to discern. I mean, it's not really what's going on here, where there is no evidence that the defendant knew. You must also keep in mind that where a defendant at the time the crime is committed had a mental disease or defect that by itself caused him to lack a substantial capacity, as I've just described, he is not criminally responsible for his conduct, regardless of whether he used or did not use drugs or alcohol. That is true, even if he did use alcohol or drugs, and the alcohol or drug use made the symptoms worse. So, and these get given, this last one gets given no matter what. In a moment, I will instruct you on the elements of the offense that the Commonwealth alleges the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. And it's so one again is that at the time of the crime, the defendant did not suffer from a mental disease or defect. That he did, but he could appreciate the wrongfulness and could conform his conduct. And then 3, where there is evidence the defendant consumed drugs or alcohol, that the defendant lacked the substantial capacity to appreciate the wrongfulness of his criminality, of his conduct, or to conform it to law. And this capacity was solely the result of drugs or alcohol and not mental disease or defect. And then the last one remains the same as well, that if the defendant lacks substantial capacity because of a combination of mental disease and defect, his voluntary intoxication from alcohol or other drugs, he knew or should have known that his intoxication would interact with his mental disease or defect and cause him to lose such capacity. Okay. So here are the consequences of a verdict of not guilty by lack of criminal responsibility. This is kind of where I paused before. And I'll pause again just to see if there's anything new. And I'll let you guys talk amongst yourself while my daughter and I snarf some food down, as my husband would say. Be right back.
This court's now in session. Please be seated.
Your Honor, for the purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, including the defendant and including the 18 jurors.
All right, thank you, Madam Clerk. Thank you, members of the jury. We're going to now return to the Commonwealth's presentation. Ms. Sprague?
Thank you, Your Honor. Commonwealth calls Joshua McKelligan.
Good afternoon, sir. Can you stop right here? We right up to the clerk, please.
Good afternoon. Do you solemnly swear that the testimony and the evidence you shall give to the court and the jury will not be between Commonwealth and the whole truth and nothing but the truth? Thank you, sir. You may proceed.
Watch your step, please.
All right, good afternoon, sir. Jury Sprague.
Thank you, Your Honor. Good afternoon. Can you please state and spell your name for the record?
Joshua McKelligan, McKelligan.
Where do you work?
Massachusetts State Police,
How long have you been with the state police?
since December 2013.
In January of 2023, where were you assigned?
To the Plymouth County District Attorney's Office.
And what was your role there?
I was a trooper assigned to the homicide and major crime section.
And could you tell us within that unit what the role of a case officer is?
Case officer is assigned cases as they come in, and the case officer then is the point of contact for the district attorney's office, the state police, other agencies.
And as a case officer for a homicide, for example, when you respond to a scene and you're doing the investigation as time progresses, is the case officer doing every part of the investigation?
No.
What is the role of a case officer in terms of managing or collecting information?
Is to try to gather everything, and then we try to keep track of what's been going on with the investigation.
And so within the State Police Detective Unit at the Plymouth County DA's office, there are a group of troopers that work there, correct?
Yes.
And do you work as a team on any homicide investigations you're working on?
Yes.
And the case officer, is it their role to collect information and evidence from the other troopers as they gather it?
Yes.
Do you have a supervisor when you are the case officer?
Yes.
I want to direct your attention to January 24th, 2023. Did you learn that day of an incident that had happened at 47 Summer Street in Duxbury?
I did.
What time did you learn about that approximately?
About 6:45 p.m.
PM?
PM.
And how did you learn that information?
The duty lieutenant in the state police headquarters in Middleborough called me.
Once you had that information, what did you do?
I called my supervisor and then responded to Duxbury.
And where in Duxbury did you respond?
I went to Duxbury Police Station.
And at that point in time, did you know that you were going to be the case officer for this case?
Not when I responded, but at the police station, I was informed I was going to be.
And at some point in time, did you go to 47 Summer Street in Duxbury?
I did.
And when was that?
After I got a search warrant, I went to the house. It was probably, I think, around early morning, between 3 and 4, sometime like that.
Between 3 and 4 a.m.?
Yes.
So it'd be the early morning hours of January 25th, 2023?
Yes.
And did you take part in the search of the home?
I did not.
What was your role there at the home that night or in the early morning hours?
I just went to observe the house, just to see what the scene in the house looked like.
So other officers were conducting the search?
Yes.
At the scene, did you eventually walk through the house?
Yes.
And was that before or after the search was executed?
After the search.
At some point in time, did you go into the master bedroom on the second floor?
Yes.
And what did you observe in that room?
I remember a tent style, like covering a crib, I believe. There was a mirror in front of me. To the left, there was the bed. And then I remember blood on the floor.
And you said to the left, but pointed with your right arm?
No, it was my left hand.
Your left, okay.
Yes.
All right. So you go into the bedroom, and what do you see anything on the floor, on the walls, the bedding, anything?
Yes, just going off of memory, I remember there was blood on the floor, and the mirror was kind of like straight ahead from the entrance of the door.
Okay. And was a video taken of the house that included that room in particular?
Yes.
I'd like to move to submit the scene video from the home as the next exhibit.
Any objection?
No.
All right, that may be admitted.
164.
And if we could play the portion of the video for the master bedroom.
Sure.
Thank you. Sir, when you went into the master bedroom, did you see blood sprayed all over the walls and everywhere?
No.
And fair to say that the video shows all of the walls in the bedroom and doesn't show any spatter or anything on the walls?
Yes.
Did you also go outside into the backyard and look at the exterior of the home?
Yes.
We could have the photos, please. zoom in on the top window. Does this photo show the condition of the upstairs window, the second floor window that leads to the master bedroom?
Yes.
And the screen there in the video, is that how it was when you saw it that night?
Yes.
Pushed up?
Yes.
And if we could see the next photo. Maybe go back to the first one. Actually, we can go back. Yes, so the first one and zoom in the middle there between the two windows. And these areas of red-brown stains on the exterior of the house, did you observe those that night on in the early morning hours of January 25th, 2023?
Yes.
And then the third photo, please. We could zoom in on the in there. Would this be this third photo? Would this be the first floor window below the master bedroom window?
Yes.
And these red-brown stains on the shingles, and then on the window ledge there. Were those there in the early morning hours of January 25th, 2023?
Yes.
Could we have these three photos marked as the next exhibit on the disc?
Any objection? All right, they may be admitted.
Exhibit 265. Now, as the investigation proceeded, did you learn, or did other officers learn from Patrick Clancy that the defendant was on some psychiatric medication?
Yes.
And was that information relayed to you in terms of preparing the search warrant?
Yes.
And is that why you included prescription medication in the search warrant?
Yes.
At that point in time, did you or any of the other officers know that the defendant had crushed up pills and taken them that night?
No.
At some point in time, did Patrick Clancy bring pill bottles to the state police and turn them over?
Yes, he did.
And where did he say those were from?
In the center console of his truck, not the top section, the section underneath it.
Did he tell you at some point that pills had been found in the nightstand drawer?
Yes, he did.
And that was in the master bedroom?
Yes.
And did he tell you who he found those with?
Yes, he did.
And who was that?
His attorney?
And did he tell you why he gave those pills?
Objection, I believe it was me, and I'm not his attorney.
But that's what, why don't you re-ask that, what it was that Patrick Clancy said?
What was it that Patrick Clancy said? Did he give you a name or just say my attorney?
He said Kevin Reddington.
And did he tell you why he gave the pills to Attorney Reddington instead of giving them to you like he gave the other pills?
No, he did not.
He never attempted to turn those pills into the state police, or those bottles into the state police. Is that correct?
Correct.
At some point in time, did you learn that the Clancy family had gone to the Museum of Science on January 8th, 2023?
Yes.
And was a video obtained?
Yes.
Did you watch that video?
Yes.
Did you observe the family, including the defendant, interacting with each other, and the defendant specifically interacting with the children and exhibits at the museum?
Yes.
Your Honor, at this point in time, Exhibit 14, I'd ask to play just a small portion of that. That has not been played previously.
All right.
We could pause here for just a moment. Do you see the Clancy family in this video footage?
Yes.
And if you could just get up and point to them with the court's permission.
Sure.
Okay. We could press play. And at this point in time in the video, are we seeing Patrick Clancy take Dawson Clancy out of that room, leaving Lindsay Clancy with Callan and Cora?
Yes.
Is that Cora there in the red skirt?
Yes.
Now, at this point in the video, at approximately 11:58 and 30 seconds, what is happening in the video footage now?
Cora's beginning to play with the exhibit. Patrick's standing off by himself. Lindsay Clancy is with Callan, and Dawson is watching.
Could you just point out where Patrick and Dawson are? For the record, you've pointed to Patrick towards the top of the screen and Dawson near the entrance to the exhibit.
Yes. Yes.
And throughout this video, in this portion of the video, can the defendant be seen instructing the children, pointing to them, showing them how to work the exhibit and operating some type of control panel?
Yes.
And at some point, does this switch and the defendant helps Dawson with the same exhibit?
Yes.
And that goes on for several minutes?
Yes, I believe so.
And showing, I think we've gone forward to approximately noon in the video timer. Thank you. Excuse me.
Oh, man.
Sir, during the grand jury process, did you attend a meeting with the medical examiner in this case?
Yes.
And did you participate in interviewing her, specifically Dr. Barbara Vidal Olson?
Yes.
And did you participate in interviewing her, specifically the portion of her proposed testimony where she was explaining how someone dies from strangulation?
Yes.
And would it be fair to say that at some point in time, she was asked?
Objection.
Counsel sidebar.
What? Aren't they not supposed to be back yet? Why are they back so early? Or did they leave late? I'm sorry. I'm glad Tracy was here to get the trial started back up.
When
So
did they start lunch? 12?
I don't know. Wait, I've got to get to the. Let's see. See, like,
That's not
oh.
bad.
All right, well, it's still on. I'm live and it's still. Switch
But
me.
it's on, but you're paused. You're paused.
Oh, God. Oh, boy. That's horrifying. Jesus. Just you do it.
What?
What?
They ended the stream.
Why would they do that?
I don't know.
What? Wait, maybe we blooped right past it.
room, leaving Lindsay. No further questions, thank you. Operating some type of control panel.
Yes.
Right around here, but then and when this video played, that's when they took the sidebar.
I thought she just said no further questions.
You
Oh, Tracy's.
Several minutes.
Yeah.
With just explaining
Oh, we got to get to the sidebar.
to affect death.
Oh, okay. All right. Sorry, guys.
Sir, in that meeting with the medical examiner, did she tell you that constant pressure would need to be applied even after the person went unconscious in a strangulation in order to affect death?
Yes.
Did she tell you that it takes several minutes of
What in the actual... Are you kidding me? What is happening right now? First of all, why is he getting to testify? This makes me want to rip my hair out of my head. The medical examiner explained this herself. You keep trying to get her to say something different. And how is this? He can't say what she said. Hearsay. He objected. The judge somehow is letting it in as evidence of a prior inconsistent statement of her own witness. Wow. This is ridiculous, and it makes no fucking point. You kidding me?
continuous pressure to cause
Can we
death?
not have leading questions? If this is going to be admitted, can we not have leading questions? It's for a witness.
You want to ask him what she said. And then
Do you recall, sorry,
go ahead.
do you recall what she said about the time it takes to strangle someone to death?
After unconsciousness, I think she said several minutes. It would take several more minutes for someone to die.
And would that be several more minutes of strangulation?
Yes.
Still leading.
I have no further questions, thank you.
All right. Ms. Reid.
So she asked you about the pills that were located in the master bedroom by Patrick when I was with him, right?
Yes.
And you know that Patrick indicated that after you guys had cleared the scene, finished with your investigation, seized all the pill bottles that you were able to locate, that I went in the house with him and I took a number of items, photographs, albums, things on the wall and stuff like that, right?
All I know is the pill bottles. I don't know what else you took.
Oh, just the pill bottles. And at some point I imagine the DA must have shown you this, recognize this as being the nightstand drug.
It looks similar to the one that was in the video.
See it? Look at it.
I mean, it looks similar to the one. I've never seen that. I don't know.
Okay. So these would be the bottles that were in there, right?
I don't know.
I don't know. And do you know that when these were seized, the first thing that was done is I contacted the DA's office and said that I had them?
I don't know what you said to them.
If you want to come by my office and pick up anything they had, you're welcome to look at it, seize it, have it analyzed, send it to a crime lab. I didn't care.
I don't know what you said.
Oh, yeah. Thank you.
All right. Hey, redirect.
No, Your Honor.
All right. Thank you, sir. Thank you. Thank you. All right. Hey, Counsel, could I see it? Excuse you, rest stop, going to stretch, that you're going to be some couple of days. All right. So you don't have to come in here tomorrow. So I'm going to suggest that take these next couple of days, rest up. I know it's been a long couple of weeks for you. I appreciate all the work that you've done. I'm going to really remind you of those instructions because now I've got kind of a longer stretch that you're going to be at home, you're going to be talking to people. So I just want to remind you, do not talk about this case with anyone. Don't do any research about this case or similar cases. If you have any questions, when you that's on the jury, and so we're going to recess on this matter for you at this point. So I'm going to excuse you Monday morning. All right. So you don't have to come in here tomorrow. So I'm going to suggest that take these next couple of days and rest up. And it's been a long couple of weeks. Do not talk. Don't do any. Don't make getting the arguments of the attorneys. You haven't heard the law that you do apply. So I'm just reminding you have to do that. It's so important. And so I just kind of wanted to remind you on that Monday. But we'll see you on Monday. We'll continue with the trial at that point. And again.
Wait, did I miss something? You guys are all saying like we missed a big chunk of it. What did I do? No, the Commonwealth did not rest. Okay. That was me rewinding and because I thought you guys said like I missed something.
We're going to address the Commonwealth's motion regarding trial court security logs.
Thank you.
Counsel?
Your Honor, the Commonwealth is asking the court to allow the Commonwealth and the defense to have copies of a log that we were advised that, or we've seen, that the trial court security has for people who go back into the lockup area to visit with or tend to or what have you with the defendant during the course of this trial. Both myself and Atty. Sprague have witnessed at several points. Obviously, we know there are medical staff that go back with the defendant, but in addition to medical staff, which are not really the primary thrust of this motion.
What?
It's that there have been other individuals that are not counsel that are permitted to go back there. And we're not alleging that that's inappropriate in any way, shape, or form. Clearly, the staff here, the security staff, has followed all appropriate protocols. But we are aware that Dr. Zeizel has been back there. We witnessed a priest being allowed back there the other day. And we are advised that these visitors are kept as a log when they come, when they exit, what days, what times. And the Commonwealth is alleging that that's information that might be necessary for us to effectively cross-examine some of the defense witnesses that are going to be presented. Certainly with Dr. Zeizel, it could pose as a potential bias that he's there, that he's back there. He's being presented as an expert witness on the concept of criminal responsibility, and there are certain ethical rules that forensic psychiatrists and psychologists follow that he might be subject to cross-examination about, and this, and the nature of his relationship with the defendant, could be an area fraught for cross-examination. Because the court records are not, these court records, I would suggest, are not in the care, custody, and control of the Commonwealth. Procedurally, we have filed the motion as a Rule 17 motion asking for access to the records just for this defendant during the course of the trial.
I mean, you're not looking for the name of the priest who went back there, are you? I mean, I understand. I'm just trying to figure out what the scope of this is. I understand the request for Dr. Zeizel's amount of visits, because he's slated to possibly be a witness. So I understand that how that might be relevant.
Right.
The priest,
well,
I'm struggling with.
At this point, Your Honor, we haven't been furnished with exactly who defense is going to be calling as witnesses in their case. We have an idea from a witness list that was filed that keeps evolving as the trial progresses. So we don't know, for instance, if that person for some reason has a relationship to the defendant and he wishes to call her or call him for some reason. So with the exception of, again, the nurses, we don't necessarily need their information. We know the purpose for why they're there and that they don't have a role in this case. But anyone else who has been permitted back there that is outside the medical staff, I would suggest the Commonwealth is entitled to at least know, and whether we are able to use that information if it becomes more apparent when the defense was underway with their case, that would come to, that we'd have to wait and see if that's the case. But certainly the fact that counsel has announced Dr. Zeizel as a testifying witness, that's information we believe we're entitled to.
All right, Mr. Reddington?
So first of all, here's the list. They want the list. We don't need a Rule 17 and a court order. They can just go over from there to there and get the list and see who's been going in and out to see Lindsay. I don't have a problem with that by no means whatsoever. Father Bob is a Roman Catholic priest who baptized these kids, who is very, very close to Lindsay. Not in a religious sense. They just like each other. She went to Mass sporadically. She's not a devout Catholic. She's a Catholic. She has a relationship with the father at that church. And that guy has been with her for 3 years, through the hospitals, through Brigham and Women's, going to Duxbury. I haven't even talked to the guy since last week, first time I ever met him. Shook his hand. Nice man. After that debacle yesterday that we went through with the public.
Let's stay focused on.
I am staying focused.
Well,
this is what I'm doing.
I don't. I guess I'll tell you right now, so I can save you. I'm not ordering the name or address of anyone other than Dr. Zeizel.
Can I call him as a witness right now?
Well,
What is involved in this? With calling
No. I'm gonna allow that so the Commonwealth can take a look at that record. Nobody else though. And then at some point, if the doctor is called, we may need if we have to address that, we can address it. So I'm going to allow the Commonwealth to have the information regarding Dr. Zeizel, and that's
I already
it. Though.
have that.
Anyone else who went back there has been admitted pursuant to the appropriate rules of the security department in this case. Especially, I'm not ordering the name, address, or frequency of this Roman Catholic priest. I'm just not going to do it based on the record that I have now. If for some reason he's called as a witness, which I haven't seen that, I haven't seen an expectation even regards that. If that comes up, then the Commonwealth can renew this, and I may reevaluate. But right now, the Commonwealth's motion regarding security logs is allowed as to Dr. Paul Zeizel only.
What she's really
All right.
looking at is what
Anything else we need to address before Monday?
that's what
Commonwealth?
No, Your Honor.
All right, Mr. Reddington?
No, thank you.
All right. So we'll see everybody on Monday. Thank you.
Court, all rise.
I mean, they know Dr. Zeizel's name, address, and identifying information. So, whoop-de-doo, prosecution. And Cam was saying she thinks they just really wanted to bug people.
Yeah. They're just bothered by Lindsay having human contact.
Right.
Oh, she's seeing a priest?
And then any human wants to contact her. There. Now people can hear you too. Man. I can't even believe it. It's just, oh no. Good talk, Cam.
Oh. So, do we know how many? I haven't looked at the witness list for the defense.
We do not. I haven't looked.
We
at
don't have
either.
it. Oh,
I mean, it's probably somewhere. Let's go through these.
can you say the Commonwealth is miserable AF? Ridiculous. Yeah.
Jersey girl.
Jersey girl Trey. Well, thank you. And yes, you can definitely say that as of right now. What? Oh. We have Afton Forred or Forred. Gifted 5 memberships.
Yeah.
Thank
for red.
you. Oh.
Like.
Oh, I see. Clever. Thanks. And family hugs to the people who got those memberships. That's cool. We have a couple jewels from Kristen and Jean.
Just say thanks for the jewels.
Okay.
Kelly Steffi loves a feisty alley.
Everyone loves a feisty alley. Mama Loca says, when you have another baby, the older children feel jealous. So when you can give the older children more attention. JFC.
Effing Christ.
Oh. This woman. Yeah. A lot of tense emotions from how the Commonwealth acted today.
Just click on them. Yeah.
Okay.
Some more jewels. We love the jewels. Lots of jewels.
You know, people talk about how you're all up in arms about the jewel addressment.
No, I love the jewels, but I just don't think you need to read the name.
But it's a little corgi, though.
It's a little whatty?
A corgi. Those
Oh.
dogs with the big butts.
Oh. Big butt dog.
Mm-hmm.
Lots of jewels. Love you guys for sending the jewels. Music to My Soul says, does finding that mean I'm a lawyer now? See, we're starting below. So I've got, oh, because Music to My Soul sent me the more up-to-date version of the jury instruction than we've been reading. Thank you, Music to My Soul. I think you're
it qualifies.
Yeah, like a junior JD. Juris Doctorate. Yeah. Allie, court is back. Cam and I were eating, we were talking.
She spent her hard-earned money to let you know you were really slacking.
Yeah.
Really slacking. Summer says, I find it odd that the state hasn't called Lindsay's current inpatient psychiatrist to the stand. If she wasn't truly suffering from psychosis, the psych staff caring for her would know. That's interesting. And I guess we haven't looked through the defense's witness list, so maybe that's someone who Reddington could be calling up, but I have no clue. I am interested to see who Reddington calls up, though. I'm excited for the defense's witnesses.
All right, so that's where we ended. So I think.
Oh, you got through all these?
Yes. Score. So.
There's nothing further up?
Wait, no, nothing up. Just go down.
Oh, okay.
Start at the bottom. Because we got some more jewels. Let's go all the way down.
Was this something? Oh,
Wait.
We started here?
Yeah. Got some jewels. You guys are really generous with the jewels. Loving it. Loving it. All right. So, I mean, I think that was the Commonwealth's last witness, but they didn't rest. So could there be another one? Here.
What made you think that that was the last witness?
Dad said, let's see. Dad said there was only 2 witnesses left.
You gotta scroll down.
Wait, what am I doing here?
I don't know.
Oh, this is it. 13. Okay. What? Why is it showing us 4 hours ago? Oh, because somebody commented?
No, it's just a thread. You know, they can't see what we're talking about, so we
I know,
probably
so
just...
we're looking at Bob's, but it should be going, oh. I don't know why it's going backwards. It should be going from most recent to...
Well, not when it's a thread, though, because these are all connected, so you have to read them in
so he says
the order they were
Commonwealth
posted.
Is now whining about Dr. Zeizel and the priest going back in the holding cell where Lindsay is held during breaks. They want the logs of people who have gone back. Is there anything more recent than that?
Kevin views yesterday's proceedings as a debacle.
Yeah. As I suspect. Should I grab my phone?
For what?
I just don't know if Dad said anything else. Like, are they going to close tomorrow? Well, Bob is in the courtroom in person. We are doing our mental health awareness day tomorrow, late afternoon. So if you've not already subscribed on YouTube, get subscribed on YouTube. So you know when it's coming and you get notified. And let's just goodbye to everybody. All right. We love you. We'll see you tomorrow. Bye.
Bye, guys.